All right, it's Outcast Podcast coming to you live here on YouTube. This is the body dumped murder trial coming to you here. It's 23-year-old McKinley is charged with murder and kidnapping after allegedly killing Melody Hoffmanin in February. The two were in a romantic relationship. That's basically all I know. We know the same thing here. So here we go with the dump body trial on the Outcast Podcast. Trying to get us a start point here, so we don't have to go through all this. All right, went off and back on. All right, here we go. Pick up the bar. All right, here we go, folks.
What's that? All right, so do we want to go ahead and do the motion now? So both sides ready for that? All right, so we're here in FECR 153477, State of Iowa versus McKinley Louisma. The state is present by Lynn County Attorney Nick Maybanks, First Assistant Monica Slaughter. Defendant is present with Attorney Jill Eimerman. Matthew Moore is not present. I understand is coming. Ms. Eimerman, you indicated before we went on the record that the motion that we were here to argue is a motion that you had filed and that you were arguing. Is that correct?
It is correct.
And are you prepared to go forward in Mr. Moore's absence today?
I am.
All right. And so the motion that we're going to hear is this not working? All right, great. All right, so the motion that we're here for is the defense's objection to amendment to minutes of testimony and motion to exclude that was filed November 1st. I've reviewed that. I've also received the defense's facts in support of objection to amendment filed on November 3rd, and I received the state's resistance to defendant's motion to exclude filed this morning, November 4th. My understanding is that this motion concerns the state's proposed exhibits 10M-1 through 10M-4, which are text messages received through the Text Now service. Is that correct, Ms. Eimerman?
Yes, Your Honor.
And then the associated testimony that would be offered by Special Agent Ryan Kedley and Megan Hoffman. Is that correct?
Yes, Your Honor.
All right, would you like to be heard on the motion?
Your Honor, I filed both the motion and I filed my additional support, and I would stand on that.
All right. Before I let the state respond, one thing I wanted to highlight and let each side be aware of and respond to is it appears to me that both sides are citing to the rules of criminal procedure that predate our current rules. And there are differences on this particular issue between those two rules. So the current rules were effective July 1st, 2023. Applied to criminal cases already pending on that date. This case was filed in 2024. And I think importantly, under the new rules, the indictment and information was separated from the minutes. I don't know that it substantively matters, but that language about bringing a wholly new charge is no longer part of the rule as it pertains to minutes under the new rules. And so I just would like the defense and then the state to have an opportunity to comment on that if you believe that I'm incorrect or that you think that it's not a meaningful difference. But as I look at the rules, the rule of relevance is Rule 2.19 sub 2. And the amendment rule is Rule 2.4 sub 7B.
Thank you, Judge. Would the court allow me to remain seated?
You please do.
Okay, thank you. I appreciate the distinction that the court is making and noticed that when I was looking at some of the cases. I do believe that there is very much a distinction. However, in this case, I think it's moot in that I think both apply. When you look at the trial information, the actual charging document, it refers to kidnapping, I think, in basically the definition and then kind of the elements. It doesn't specifically delineate which of the theories it is alleging. However, the language of the trial information does set forth which of the theories of kidnapping. So I believe that this amendment is in fact an amendment to the trial information and the charging document in that it adds an additional theory that was not otherwise pled. I also believe that there is an issue with the minutes of testimony because the minutes of testimony do add additional and new facts to the case. So again, yes, I agree with the court that there is a distinction. However, in this case, I believe what the state is seeking essentially violates both.
At this point, the state is not asked to amend the trial information to seek a different theory, but factually these minutes do that.
Correct.
And my main point, though, was just to indicate that I think the operative rule with regard to minutes is Rule 2.19 sub 2. And so I wanted to give an opportunity to indicate whether you agreed with that or disagreed.
I do agree with that. And I would ask that I guess to the extent that my written motions don't delineate that, that in my argument, I am addressing both of those. Thank you.
Great, thank you. Would the state like to respond?
Thank you, yes, as the court has made counsel aware, Rule 2.19, subsection 2, Iowa procedure 2024, new edition here, contain language involving amendment plans that would present a wholly different offense. However, even if that was the standard under the case law cited by the state and its resistance, we believe that this is not a wholly new different offense. This is simply a different means of committing the same offense, which is supported by the case law citing state penalty, in particular, the 2021 Iowa Supreme Court case, as well as the project case cited specifically stating the sheriff that says allowing them to charge maybe kidnapping first degree is allowed. And yes, the state acknowledges that this information is new, and we laid out how it came to our attention and how we immediately provided defense movements for that. At this point in time, the state has not moved to amend the trial information in this case. However, rules do allow the state to, if needed, to do that during the course of the trial before the rest of that as well. So we would contend that if we have the support, we can request a jury instruction on that as well. In any event, if the jury instructions or the case law was not submitted to the jury to support this particular alternative, it would still be relevant in the case at hand. Because as noted in our resistance, it's clear that the timing of these messages, even though they come from my senator, we would contend the evidence shows that they only have been sent by somebody who had knowledge that Melody Hoffmanin was still missing. There was a just brief, maybe a couple of hours between the release of this and these messages, but also more importantly that it would come from a person who would have Melody Hoffmanin's personal phone number, and that was relevant in this case either to showing circumstantially the defendant was the one who sent this, or that an accomplice of the defendant did so. We believe that given the entirety of the evidence here that this is not fairly prejudicial, and we know that to the extent that it is important that the investigation of the text down on the list is still going on.
Can you talk to me a little bit about the circumstances by which this would have only been provided to your investigator, as I understand it, on October 30th? Is that right?
That's not right, Judge. I didn't make that clear in my resistance. So this was provided to the investigator on February 18th. During a meeting with Melody Hoffmanin, Megan Hoffmanin, she brought that up because it wasn't documented before. I didn't know that. And so I confirmed that it was sent to Special Agent Kelly, who did describe to me that he recalled that, but believed, and this would be evident in the exchange between Special Agent Kelly and Megan Hoffmanin, that it was some sort of prankster or somebody trying to restore her under the circumstances, and so we didn't make any documentation of it at the time. Because I begged to differ on the importance of that, I had him do an immediate supplemental report and provide the defense with those messages. It's not an ideal way that it came about.
And so I guess I misread it then or misunderstood it. So what you're indicating is that Megan Hoffman provided the messages to the investigator on February 18th. And then when did the state become aware of it from the investigator?
I became aware of it from Megan Hoffman on Tuesday, October 29th.
Okay, and so then you became aware, and as soon as you became aware, you immediately notified the defense.
I confirmed the existence of tape messages and notified the defense just prior to filing this testimony about 24 hours.
And so, under rule, and I guess I asked this question to the defense. Do you also agree that Rule 2.19 sub 2 is the operative rule for me to consider here, which says that for minutes filed less than 10 days before trial, which includes amended minutes, that if I were to allow that the court can order the state to permit the discovery of the witness, grant a continuance, or enter such other orders deemed just under the circumstances, and if no less severe remedy is adequate to protect the defendant from undue prejudice, to order exclusion of the testimony. Yeah, the whole thing was a question.
We would contend that under 2.19 subsection 2, that this is not we're not introducing a new witness. Megan Hoffman's always been a witness in this case. It's just the particular item or incident at hand. So we would then say that the court would refer to the analysis in subsection B of that rule, subsection discovery, grant continuance, or another order to just most severe remedy here.
So, I mean, obviously, we're beyond a continuance. Permitting discovery of the witness at this point, I mean, what the defense has said in their motion is that, you know, the bulk of the state's case is going to be put on this week. They've already deposed the investigator. They've already deposed Melody Hoffmanin. I mean, what's the remedy? I mean, the more significant the evidence, and you've just made an argument that it's significant, the more important that they have an opportunity to meet it. And one concern I have is I'm not aware of any other evidence that the state has to suggest kidnapping by ransom. And so while this is not a wholly new offense, it's a wholly new way of meeting this offense that the state has no other evidence of.
So we would contend that you have, as has been laid out in Ben's testimony, and as the evidence in this case will support, the defendant and Mr. Van Patten, while Melody Hoffmanin was found and confined within the vehicle that were driving, left Morgan Park and headed directly back towards the residence of Melody Hoffmanin, where Megan Hoffmanin was. And there's very little explanation in the evidence in this case for why they would do that, and they would intend to make some kind of contact with Megan Hoffmanin. Not that it's part of the case, but there's also information that came from a co-defendant on that regard, but that's not something that the court would be able to consider. Thinking that that does rise, or at least arise, the distinct prospect that could be one of the intents of the co-defendants in this case.
Doesn't sound like anything that's going to rise to the level of getting a ransom instruction that I'm hearing.
Yeah, there's no other evidence of ransom instruction other than their activities and movements toward Megan Hoffman's residence and then this subsequent text message of the same.
So, I mean, my issue is the more you tell me about the importance of the evidence, the higher the prejudice it is if they not have some ability to conduct discovery on it. What the defense says in their resistance is, and I think it's a fair point, is that we are now in the bulk of the state's case that we presented over the next 5 days. At minimum, it would seem fair that they would be able to depose the two witnesses.
Absolutely, if that's the remedy, would be the best fix for the situation, the best way to address the situation.
Yet they say that, you know, time is limited. We're in the middle of the week. That if they do that, they're not doing something else that's essential. And of course, the rule says, or enter such other order deems just under the circumstances. I'm not sure what other remedy there would be other than exclusion.
this. So we would defer back to our position that even if these messages aren't ultimately used to be able to add a theory to the case, that being the intent to hold Melody Hoffmanin for ransom, that it does indicate and is incriminating towards the defendant due to the, again, the timing of the message, the nature of the content, knowledge that the person who's on that read had, and in particular, knowledge of an Hoffman's text phone number at the time this happened, as well as I believe that there will be similar syntax used in this message as Mr. Louisma has used in prior correspondence. So we just intend it's a probative item of evidence, even if it's not used in ransom theory.
Well, and again, the problem is that's a double-edged sword, because the more probative, the more prejudicial if the defense not have an opportunity to meet it. I mean, it's sort of inconceivable to me that a message sent from someone with knowledge prior to information being publicly available would not be included in an investigative report and turned over to the defense. It's inconceivable to me. And this is not blaming the state. It sounds like you were not aware of it, and as soon as you were aware of it, it was immediately turned over. But in terms of the state actor of the investigator, it's inconceivable to me. Would the defense like to respond to any of this? And is any of what's been said different factually than what you understood when you were filing your resistance or your motion?
Your Honor has essentially articulated all of my concerns, and the more the state spoke, the more concerned I became about the substance of this evidence and its potential impact. It is far less superficial than I even initially thought it was. So I had not understood any of the evidence that I've learned over the course of this case to give rise to the theory of being held for ransom. I believe what the state has indicated today is tenuous at best, and as the court pointed out, likely insufficient to get a jury instruction on that. So at this point, I believe the only remedy that the court can really impose is to exclude the evidence.
And would you, though, respond to, again, the less severe remedy? Because the rule does, of course, caution the court that exclusion is to be seen as the last resort. In terms of those other options of permitting discovery, you indicated in your motion that the defense, in effect, didn't have time to do that, didn't want to do that, that it would take away from necessary trial preparation. That was made as sort of a conclusory statement. I certainly don't want you to get into anything that would invade, your private preparations, but can you give the court any additional information about your ability to conduct that discovery if it were permitted in short order?
I can, and I expect that this court knows well what goes into setting up depositions. If the court were to permit us to take depositions, which, to be clear, is not the remedy that we are seeking, because at this point, it's no small thing to do that, Your Honor. We've got two witnesses who would need to be deposed. We would need to find a time that would work. We would need to find a location. I would probably be tasked with finding a court reporter that was available. I would need to find a court reporter that is available to do this on a rush job, that would be able to turn around transcripts essentially immediately. At that point, are we going to be required to do that outside of trial time, or would we recess the jury and allow us to do it then? Again, this is time that, when added up, is substantial, and it's time that we are taken away from preparing to defend our client in this case. So for that reason, Judge, we're not asking for the remedy of discovery. We're asking for the remedy that it be excluded.
Thank you.
Thank you.
State like any further word on this? I am actually prepared to rule on this. So under Rule of Criminal Procedure 2.19 sub 2, the state is not permitted to introduce any witness whose minutes of testimony were not filed at least 10 days before trial. And that includes amended minutes under Rule 2.47B. If filed within 10 days, the court may order the state to permit the discovery of such witness, grant a continuance, or enter such other order it deems just under the circumstances. And if no less severe remedy is adequate to protect the defendant from undue prejudice, the court may order the exclusion of the testimony of any such witness. Obviously, the purpose of the rule requiring minutes is to provide the defendant with a full and fair statement of the anticipated testimony. An amendment within 10 days before trial may certainly be permitted, but only if it can be done in such a way as to protect the defendant from undue prejudice. Here, the additional minutes were filed on October 30th at 3:06 p.m., stating that previously listed witnesses, Ryan Kedley and Megan Hoffman, would testify that Megan Hoffman provided Kedley with screenshots of a text conversation she had with an unknown sender from a text now number approximately 10 hours after Melody Hoffman's body had been located in Iowa County. I have reviewed the text now messages, which were loaded as state's proposed exhibits 10M-1 through 10M-4. Significantly, the messages from the anonymous sender include a demand for money in exchange for the safe return of Melody Hoffman. Megan Hoffman was prompt in providing the messages to the investigator upon receipt. It's unknown why the investigator did not include this information in its report. Once the state became aware of the existence of the text messages, it was prompt in providing the information to the defense, but it's undisputed that this information was not provided to defense counsel until the state emailed defense counsel on October 30th at 2:49 p.m., immediately before filing the additional minutes. The defense previously took depositions of both Megan Hoffman and Special Agent Kedley, and the information was not known or revealed, so the defense has had no prior opportunity to explore or follow up on the evidence. The court does find that this evidence is not merely superfluous or supplemental for the primary reason that it provides evidence for an additional element not previously alleged in the facts by which defendant could be convicted of kidnapping. In Iowa Code Section 710.1, the definition of kidnapping requires that the act be accompanied by one or more items, one of which is the intent to hold a person for ransom, and the text now messages is the only direct evidence that the court is aware of in this case, which would support a kidnapping conviction based on ransom. Additionally, while the text now messages are anonymous, the evidence is nonetheless somewhat probative of identity in this case, particularly due to the court's limine ruling that a separate anonymous text now message sent around the time of defendant's breakup with the alleged victim could be received based on the content and timing of that message and based on Megan Hoffman's expected testimony that Melody Hoffman had no one else in her life that would send such a message at that time. Assuming that the jury believes that the defendant sent the earlier message using the text now service, it's more likely that the jury may believe that the later text now messages were also sent by the same sender. Given that the text now messages provide an additional basis for kidnapping and may have additional probative value regarding identity, the defendant's need for further investigation is not imagined or exaggerated. It is not the type of exploration that would wisely be done cold through cross-examination in front of the jury. Obviously, continuance of trial cannot be granted at this point. The court has considered whether it can permit discovery of the witness or provide other remedies short of exclusion to provide the defendant and protect the defendant from prejudice. Defense counsel has stated that it cannot devote time to investigate these details with the two witnesses without sacrificing time otherwise needed in trial preparation, which the court finds to be a reasonable position, given that almost the entirety of the state's case will be offered this week. An investigation of these details would at minimum require additional depositions of the two witnesses, potential other follow-up. This is information that was in possession of the state's witness back in February, hours after Melody Hoffman's death. It's simply not fair or reasonable to expect defense counsel to now use its trial preparation time to chase a new discovery issue and be faced with defending a new theory of kidnapping during the week that the state is putting on almost the entirety of its case. While the court finds that exclusion of evidence should be a last resort, it is unfortunately the only remedy available to the court under the timing and circumstances, which will avoid undue prejudice to the defendant. Therefore, defendant's objection to amendment to the minutes of testimony for witnesses Megan Hoffman and Ryan Headley as to the text now messages filed October 30, 2024 is sustained, and the motion to exclude that testimony and those proposed exhibits is granted. So let's go ahead and take just a few minute break so you can get set up for your openings. And while we're doing that, if you want to test your technology, you can do that as well. Go off the record.
I'm actually at Lily Lake in Amana, and it looks like a dead body here. I'm with a couple other people.
Monica, can we try?
Are you getting this one? This one's working? Let me check this one too. Anything from this one? You are getting it now? It's really low? I mean, is this one better? What's this one like for you? So the mics aren't working, but all you have to do is hit that thing until the. Can I see it? There's 2 different stages of green lights now. Hold, can I push this for it? This is what we do. Don't do that one off.
Hours after Melody Hoffman's death. It's simply not fair or reasonable to expect defense counsel to now use its trial preparation time to chase a new discovery issue and be faced with defending a new theory of kidnapping during the week that the state is putting on almost the entirety of its case. While the court finds that exclusion of evidence should be a last resort, it is unfortunately the only remedy available to the court under the timing and circumstances which will avoid undue prejudice to the defendant. Therefore, defendant's objection to amendment to the minutes of testimony for witnesses Megan Hoffman and Ryan Headley as to the text now messages filed October 30, 2024 is sustained, and the motion to exclude that testimony and those proposed exhibits is granted. So let's go ahead and take just a few minute breaks. You can get set up for your openings, and while we're doing that, if you want to test your technology, you can do that as well. Go on the record. You can all be seated. right, we're here in case number FECR 153477, State of Iowa versus McKinley Louisma. State is present by Lynn County Attorney Nick Maybanks, First Assistant Lynn County Attorney Monica Slaughter. Defendant is present with attorneys Jill Eimerman and Matthew Moore. Welcome back, jurors. This time I ask that the state please read charge and defendant's plea.
State of Iowa versus McKinley Louisma. Trial information. Comes now Nicholas G. Maybanks as prosecuting attorney, and in the name and by the authority of the State of Iowa accuses McKinley Louisma of the crime of count 1, murder in the first degree, committed as follows. That the said McKinley Louisma on or about February 17, 2024, in the county of Lynn and State of Iowa, did unlawfully and willfully kill Melody Hoffmanin with malice aforethought, willfully, deliberately, and with premeditation, and or while participating in a forcible felony offense of kidnapping, and or aid and abet another in the commission of the offense at Morgan Creek Park, 7212 E Avenue Northwest, Cedar Rapids, Lynn County, Iowa, and or Lily Lake, 220th Trail and 38th Avenue, Amana, Iowa County, Iowa, in violation of section 707.1, 707.21a, Iowa Criminal Code. Count 2, kidnapping in the first degree, committed as follows. That the said McKinley Louisma on or about February 17, 2024, in the county of Lynn and State of Iowa, did unlawfully and willfully confine or remove Melody Hoffmanin from one place to another, knowing that he had neither the authority nor the consent of Melody Hoffmanin to do so, with the intent to secretly confine her or with the intent to inflict serious injury upon her. And as a consequence of the kidnapping, Melody Hoffmanin suffered torture and serious injury. And/or aided and abetted another in the commission of the offense at Morgan Creek Park, 7212 E Avenue Northwest, Cedar Rapids, Lynn County, Iowa, in violation of section 710.1, 710.2 Iowa Criminal Code. Count 3, conspiracy to commit a forcible felony, committed as follows. That the said McKinley Louisma, on or about February 17, 2024, in the county of Lynn and State of Iowa, did unlawfully and willfully conspire with one or more persons with the intent to promote or facilitate the commission of a forcible felony by agreeing with another that they or one or more of them will engage in conduct constituting the crime or an attempt or solicitation to commit the crime and or agree to aid in the planning or commission of the crime or of an attempt or solicitation to commit the crime at Morgan Creek, 7212 E Avenue Northwest, Cedar Rapids, Lynn County, Iowa, in violation of Iowa Code 706.1, subsection B, 706.3, subsection 1 of the Iowa Criminal Code. To these charges, the defendant has pled not guilty.
Jurors, at this time, the attorneys will have an opportunity to make opening statements. In doing so, they may explain to you what they believe the issues in the case are and what they expect the evidence will show. The statements which they now make and the arguments that they will later make after all the evidence has been received is not evidence and may not be considered by you as evidence. Also, any statements they make about the law is not to be considered as the law of the case. Since evidence often comes in piecemeal and out of chronological or logical sequence in the trial of a lawsuit, the statements of counsel are merely to put the facts in perspective. They're intended to give you a thumbnail sketch of the case and outline the evidence to better aid you in understanding the issues and the evidence. And therefore, I ask that you give them your attention. The state will give their opening first, followed by the defense. Mr. Maybanks.
Thank you, Your Honor. Depraved, dehumanizing, defies reason. The evidence in this case will show that the defendant's actions, along with his accomplice, Dakota Van Patten, on February 17th into February 18th, 2024, were depraved. The evidence in this case will show that they kidnapped, killed, and mutilated Melody Hoffmanin in a manner that can be described as nothing less than dehumanizing. The evidence in this case will show, and we will lay out for you at the end of this case, multiple possible explanations for why he did this, but all of the explanations will defy reason. Depraved, dehumanizing, defies reason. The evidence in this case will show that on February 17th, 2024, Melody Hoffmanin was a young and vibrant 20-year-old lady. She was still finding her way in the world. The evidence will show that she lived with her mom and her protector, Megan Hoffman. But the evidence will show that she was not your typical 20-year-old young lady. Melody also had an intellectual disability. Melody had the mind and maturity level of a much younger person and processed the world more like a 12 or 14-year-old girl would, but in the body of a grown adult. As the evidence will show in this case, because of who she is and what kind of person she was, she did not always make decisions that were in her best interest. Melody was more susceptible to manipulation, even control. She was overly trusting. And the evidence will show she just wanted to feel loved and included. At the time she was killed, Melody was still at home, living with her mom, while many of her peers from high school had begun to move on with their lives. The evidence will show that Melody was very social, that she craved attention. But besides her family, there just weren't a lot of other people in her lives. In particular, she craved the attention of young men and really wanted to have a boyfriend. The evidence will show the defendant, Mr. Louisma, knew Melody very well as of February 17th and 18th of 2024. He had been in a relationship, even stayed with her at her home with her mother on occasion. But the relationship failed, and the two of them broke up around the beginning of the year 2024. The defendant would promise her that he was coming over and that they could hang out, but then he'd make excuses and not show up. The evidence would show the breakup was hard on Melody, and she didn't take it very well. You see, the defendant was her first real boyfriend. She wanted to be with him, but she couldn't stay with him because he wasn't valuing her. The evidence will show the defendant, Mr. Louisma, had a lot going on in his life when this happened. He had been involved in a longer-term relationship with another young woman, Nakia Sloboda, which had gone on for approximately 4 years up to that point. There had been some struggles and strife in their relationship, and the two of them split up in the middle of 2023, which is approximately the time he began seeing Melody Hoffmanin. The evidence will show the defendant and Nakia then reconciled and were back together around the same time his relationship with Melody Hoffmanin was ending. The evidence will show the defendant was living with Nakia, but had some struggles maintaining employment. And to top things off, Nakia was pregnant with his child. The evidence will show that both of these women knew about the other. And the evidence will show that the woman with which he had the longer-term relationship and commitment was Nakia. And she told the defendant he had to choose between her and Melody. The evidence will show there was a lot of stress going on in the defendant's life. Pregnant girlfriend and an ex-girlfriend, Melody, who still wanted to be in his life, with a secret of her own that was discovered after she died. You will hear the defendant's girlfriend had pregnancy complications that day on February 17, 2024, adding to his stress. The evidence will show that this triangle, although certainly not unique, was extraordinary in the consequences that resulted from it. On February 17th, the evidence will show the defendant had a past with Melody Hoffmanin, but she wanted to have a future with him. The evidence will show he didn't. The evidence will show the defendant knew Melody well. He knew she would be willing to get into a car with him and another man, one she didn't know and who didn't know her, Dakota Van Patten. And that she would do so even though she had just broken up with him and there had been conflict between them. The evidence will show that he knew she would make that decision, which would prove to be her last. The evidence will show that Megan Hoffman, Melody's mom, was alerted to Melody's departure from their residence through a camera at approximately 11:24 p.m. on February 17, 2024. Megan immediately reached out to her and asked her what she was doing and told her to hurry back home. You will see the conversation between Megan and Melody when she left the residence, which would prove to be the last time she saw and talked to her daughter. The evidence will show Melody Hoffmanin never came back home. In this case, ladies and gentlemen of the jury, through testimony, cell phone location data, cell phone forensic information, video surveillance, physical evidence, and even DNA evidence, the state will lay out to you exactly where Melody Hoffmanin traveled with these two men, the defendant and Dakota Van Patten, and what happened during that fatal car ride. But before we do that, the state will present to you what the defendant, Dakota Van Patten, and a third man, Logan Kimpton, did prior to picking up Melody. The evidence will show that a couple of days prior to this incident, the defendant had purchased a machete from Walmart and had been researching various face coverings and face masks. You will see on surveillance video the defendant, Dakota Van Patten, and Logan Kimpton, the third man, purchasing machetes and gloves at Walmart on the southwest side of Cedar Rapids, just mere hours before the defendant picked up Melody Hoffmanin. And the evidence will show that it was not for the purposes of going camping or mudding in February of 2024. During this case, you will hear that Kimpton talked openly to others about the plan that he, the defendant, and Van Patten had. In this case, you'll be able to follow their actions as they came into contact with each other, proceeded to the Walmart on the southwest side of Cedar Rapids, and you will see that Kimpton then left the other men for the night, leaving the defendant and Van Patten together. The evidence will show they were together within an hour or so prior to picking up Melody Hoffmanin, when the defendant picked up another person, Trevor Weiss, from work at Lebowski's and drove him home. The The evidence will show the defendant would later return to Trevor Weiss's residence after all this happened and tell him to tell anyone who may ask that he and Trevor were playing video games together all night. The evidence will show the defendant and Van Patten picked up Melody from her house. Initially, they were listening to music and driving around, seemingly having a good time. But that changed when they arrived at Morgan Creek Park in Lynn County. When they arrived at Morgan Creek Park, the evidence in this case will show that Megan Hoffman, the protective mom, was watching Melody's location and determined what she already pretty much knew, that Melody was with the defendant, because she knew they had been there before and the defendant's parents lived in that area. The evidence will show they drove to this dark and secluded park in Lynn County, and that's where this fun night turned fatal. The evidence will show that the carefreeness and levity of the night turned into depravity. The evidence will show that it was at Morgan Creek Park where whatever depraved plan the defendants had came into action. Melody was beaten. You'll hear about the blunt force of the beating she took when you hear from the pathologist who conducted her autopsy. While beating her, the evidence will show they used the handle of the machete across her face, just one of the weapons they ended up using. The evidence will show they terrorized and tortured her. They bound her hands and mouth with duct tape. You'll see what they did to her because it was documented. The evidence will show they tied her up and confined her within the car and then removed her from Morgan Creek, traveling back towards Marion to conduct whatever it was their sadistic plan. Whatever reason they had for this plan, for terrorizing, tying up, and then removing her from Morgan Creek, the evidence will show the reason was depraved and it involved dehumanizing her. The evidence will show they did not treat her as any human being would ever deserve to be treated, and that she endured unspeakable trauma before she was slayed, being subjected to severe physical and emotional pain. The state will demonstrate to you where they took her and what path they took doing it. The evidence will show they traveled from Morgan Creek Park back into Marion, nearly all the way back to her house. As they were heading back to her home to carry out their plan, if there even still was a concrete plan at that time, they stopped in a parking lot not far from her house. The evidence will show that Megan Hoffman was watching her daughter's location still, wondering where Melody was at and what she was doing. The evidence will show that Megan received a message from Melody on Snapchat, but the evidence will show that it could not have been Melody talking to her or messaging her at that time. The evidence will show was these men working in concert, and likely that it was the defendant directly communicating with Megan. You will see this conversation and you will see that they indicated to Megan that Melody was nearby and heading home soon. The evidence will show that Megan demanded that Melody come home. And then the evidence will show in this case that the defendant and Van Patten encountered a Marion police car. And that at approximately the same time they did that, the location detection on Melody's phone was shut off and they left the area. The evidence will show that the defendant, Van Patten, and Melody Hoffman kidnapped, tortured, injured, and restrained, then traveled to Lily Pond in Amana, Iowa. her final destination, the last journey of her life. The evidence will show that the defendant had intimate knowledge of Lily Pond and where it was. In this case, you'll see what happened next. And it will be shocking. And you might want to understand why it happened. But the evidence shows you whatever reason it happened defies reason. Because it was irrational, depraved, dehumanizing, and deadly. You see, the evidence will show you, and you will infer, that the defendants decided it had gone too far and they needed to end it. The evidence will show you they decided they needed to end their plan, whatever it was, end the activities for the night before they got caught, and end Melody's life. The evidence will show you when they arrived at Lily Pond, a place the defendant knew very well, the defendant and Van Patten strangled Melody with a paracord. The defendant and Van Patten stabbed her with a knife. The defendant and Van Patten slashed her back. The defendant and Van Patten mutilated her body. The evidence will show it was likely done to stage what her body would look like after being attacked. And if that wasn't the reason, the evidence would only be explainable by some other depraved and senseless reason, the likes of which reasonable minds can hardly construe. The evidence will show that the defendant, with Dakota Van Patten by his side, strangled Melody, stripped Melody, mutilated her body, and left her for dead on the shore of a chilly pond in rural Iowa County. And with that, the defendant also left behind, the evidence will show, at least part of the problems he was having in his life. 20 years of happiness, innocence, zest for life gone within a matter of hours. The evidence will show there were different possible reasons for why this happened. Animosity in the breakup, ridding himself of Melody so he could stay with Nakia and they could go on with their lives, some kind of twisted plan that went too far. But the evidence will also show another potential motive that could have been the sole reason in and of itself, or an additional motive on top of any other motive or reasons we might not know and don't have to prove. You see, the evidence will show, and you will hear, that Melody Hoffmanin was either pregnant at the time of her death or had recently been pregnant. The evidence will show that at approximately 2:24 a.m. on February 18th, 2024, the defendant, Dakota Van Patten, snuffed out Melody's life and left her body at Lily Pond. The evidence will show that while Melody lay lifeless on the shore of Lily Pond, the defendant and Dakota Van Patten got back into the car, listened to some music, traveled back into Cedar Rapids, bought some cigars, and then went home. The evidence will show the defendant dropped off Dakota Van Patten at the home of Taya Meyer, and that Dakota Van Patten had a conversation with Taya Meyer about what happened that night. The evidence will show the defendant went back home to his girlfriend, Nakia, kissed her, told her he loved her, sat down, and looked at his phone. You'll hear what was found on his phone, and you'll see it as well. The evidence will show the defendant took one last look at what was on his phone and deleted it as if the subject matter never existed. The evidence will show that when Van Patten was dropped off that night, and when the defendant went home, the defendant's car was also left on Hummingbird Lane in Hiawatha, where he was living. The car was seized, and the contents of the trunk of the cab of the car helped shed light on what happened to Melody and how the defendant and Van Patten conspired to kidnap her, did kidnap her, and kill her. What they found in the trunk of the car was deeply incriminating. What they found was a kidnapper's grab bag containing compelling and shocking evidence of the plight that Melody Hoffmanin endured at their hands. Her clothes, with duct tape still on them. A paracord that was used to strangle her to death. A knife with her blood on it. A machete with a handle that matched the mark across her face. The evidence will show the defendant handled all of these items because he would admit to Special Agent Kedley of the DCI that he handled all of these items. And the DNA analysis of those items will also confirm they were used to kidnap and kill Melody Hoffmanin, that they were handled by Van Patten, and that they were handled by McKinley Louisma, as he admitted that he did. You will hear from Dr. Kelly Cruz from the Iowa State Medical Examiner's Office, who will explain to you that Melody died from strangulation, and that the ligature marks on her on her neck matched the paracord found in the defendant's trunk. The evidence will show the knife in the defendant's car that he admitted to having in his possession that night was also consistent with the stab wounds and slash wounds on Melody's body. The evidence will show these wounds were inflicted, likely, post-mortem. And you will infer that it was either done for staging purposes or for some unknown reason that, quite frankly, defies any rational explanation. The evidence will show she was strangled, stabbed, mutilated, stripped, and left face down on the shore of that pond. Dead at the hands of the defendant and Dakota Van Patten. At the end of this case, we will return to you, break down for you, nearly to the minute, proving to you each and every one of these facts that I've asserted to you are facts in this case, and demonstrate to you how the evidence in this case shows the defendant and Dakota Van Patten acted as primary perpetrators and as aiders and abettors to each other in the conspiracy, kidnapping, and murder of 20-year-old Melody Hoffmanin. And we'll show that to you to any doubt, beyond any doubt that is reasonable. And when we lay out for you the evidence in this case and the instructions that the court gives to you, we will ask you for verdicts of guilty to murder in the first degree, kidnapping in the first degree, and conspiracy to commit a first degree.
Thank you, Mr. Maddox. Defense will now have an opportunity to give an opening statement. Ms. Emmerman?
However, this case is not nearly
state says frequently they. But there was no plan. There was no,
Because that's a picture.
they were not acting in concert. There was no, the defendant did not. Because while he was there, he did not strangle her. While he was there, he did not cut her. While he was there, he did not beat her. While he was there, he did not kill her. Heard that there were a number of items that were found in his trunk. We heard that there were looking DNA evidence about these items. While McKinley may have said that he handled those items at one time, he did not use those items to kill Melody Hoffmanin. What we will hear about this is not that none of them belong. Among those items, there was DNA that could be matched to the DNA. There was DNA that could be matched to three individuals were Melody Hoffmanin. This case really over the course of the next few days, we will hear from witnesses. They will talk about the evidence that was found in this case. After hearing all of that evidence, after considering all of that evidence, you will determine that the state has come up short. The state has not proven beyond a reasonable doubt that our client, that McKinley Louisma, is guilty of the charges that the state is alleged in this case.
Thank you, Ms. Iberman. At this time, we will proceed with the presentation of evidence. Is the state prepared to offer its first witness? You may.
Yes, I do.
Amy Lynn Robas, R-O-B as in boy, A, S like Sam, S like Sam, E. I live in the Amana area. 4 years. I'm sorry. I'm currently not working due to medical issues, but Until the beginning of this year, I was the executive director of a small nonprofit for people with disabilities.
Were you living in the Amana area on or about?
Yes, I was.
Remember what you were doing morning to break?
Yes, I do. I went to Lily Lake or Lily Pond, depending on who you're talking to, and was sitting in the parking lot in my car, listening to an audiobook, watching the geese and the ducks, thinking about what I wanted to do for the day and some things that were going on in my life at that time. Yes. Yes, I usually go there a couple times a week at least, depending on weather. Peaceful, sort of quiet. There's not much there except the lake, and there's a couple of picnic benches right along the shore by the parking lot, and a lot of people park there and walk the trail that goes around the lake. Few people will go and picnic there, but for the most part, people will park and do what I was doing and sort of sit and talk on the phone. I've seen a lot of residents sit and have lunch and just kind of appreciate the beauty of the spot while they're doing things that they need to do, sort of making their days a little bit better, I think, with that nice, pretty view.
Prior to today's date, did you see a picture of the aerial view?
Yes, I did.
And if you saw that, would you be able to identify the area?
Yes, I would.
And was that a fair and accurate depiction of that area?
Yes, it was.
Any objection to Exhibit 2?
No, Your Honor.
Exhibit 2 is admitted. You may publish.
What are we looking at here? It says
An aerial view of Walford heading towards Amana.
is that showing it's highway 151 goes south?
Yes. Lily Pond or Lily Lake, depending on who you're talking to.
Probably called.
That's usually how it goes.
And is that where you were at in this location?
Yes, it was.
What time did you arrive?
Around 9:30.
When you arrived, was there anyone else there?
Not at that time.
Maybe the only car there?
When I arrived, yes.
While you were there, what did you do?
I was listening to my audiobook and just thinking and looking out the window.
While you were there, did anyone else arrive?
Yes, there were two other cars that came and sort of did what I was doing. They sat and they were actually on their phones and talking and then left after a few minutes. And then I had a couple approach my vehicle on foot.
Was the weather condition?
Overcast, kind of foggy.
When this couple approached you, they didn't
They were acting strange. I actually felt really nervous seeing them because they were clearly agitated. They were older than I am and coming towards me kind of waving. And so I rolled down my window and they were immediately asking for help. And so I ended up getting out of my vehicle to find out what was going on. Yeah, they pointed
Emily,
towards
with the tiny Donnie, thank you.
the shore behind the picnic pavilion at the Lily Lake and said that they had been walking and saw something over there and they didn't know what it was, if it was a dead animal or if it was a mannequin or if somebody was playing some kind of prank, and would I go over there and look. I would say I think I'd probably been there about 20 minutes. Yeah, as soon as I exited my vehicle and started walking that direction, I was able to see that there was a human body and that it was not moving. And so I called 911 as I was walking that way. I don't know that it was the feet so much as like there's a divot, the elevation changes a little bit where the body was, and so once I exited my vehicle, started walking, the way my line of vision changed, and then it was easy to see her, but that was probably about 10 feet from my vehicle that I noticed.
So were you unable to see this body?
I would say it was a combination of the landscaping and the fog. Once I knew she was there, I probably could have seen her, but with the landscaping and the fog and just not expecting to see anything like that, it was not easy. It was a young female. I could tell I knew she was young because she had the most beautiful, pale, perfect skin and glorious curls. And she was not moving in any way, shape, or form. She was not appropriately clothed. There were slashes and gashes all over her. Her hands were curled in a way that they shouldn't have been. She was not breathing. I was fairly confident, just even from a distance, that based on positioning, the temperature, the way she was laying, not being clothed appropriately, that she was deceased. I know she still had underwear, and I believe she still had a bra. Honestly, I've tried to forget. I try not to think of her like that. But I remember also her underwear wasn't on correctly, and so when I called 911, I also mentioned that I thought she might have been sexually assaulted. She was laying on her stomach. I could not see her face. Yes, and I also saw wounds on her body that I thought might have been post-mortem wounds. There was no blood on them. It's what it looked like to me. I've never seen that in real life, but I've read about it.
Did you see anything else about her while you were
When I was talking to emergency personnel, I noticed she had goosebumps. And I, at that moment, thought maybe I was wrong because she had goosebumps. So maybe she just was not well and really cold. And I told 911 and they said, no, don't. Because I thought maybe they would tell me to go assess her. And they said, absolutely stay back. Don't touch her, which I had not at that point, nor did I. Yes, goosebumps can be an indication of rigor mortis.
Objection, competence, Your Honor.
Sustained. Jury will disregard the last answer.
No, I did not. Yes, I did.
You may.
And prior to today's date, Ms. Robots, did you have an opportunity to do a 911 call that you made to the Iowa County Sheriff's Office?
Yes, I did.
Is that a fair and accurate report?
Yes, it was.
Move to admit State's Exhibit number 4, Your Honor.
Any objection to 4? Exhibit 4 is admitted.
Not handed to this was marked as State's Exhibit number 5. Did you also end up receiving a phone call back from 911 to get more information?
Yes, I did.
And have you had an opportunity to review that prior to today's date?
Yes, I did.
Is that also a fair and accurate reporting?
Yes, it was.
And our State's Exhibit number 5, Your Honor?
Any objection to 5? 5 is admitted.
Permission to publish.
You may do so.
Iowa County 911, what is the address of your emergency? I'm actually at Lily Lake in Amana, and there's it looks like a dead body here. I'm with a couple other people. They said don't turn on the sirens. Okay, here at the Lily Pond? Yeah, right by the, where the picnic area, the pavilion is. Okay. It's a woman, and she's just wearing underwear. Is she breathing? It does not look like it. Do you see her chest rising and falling? She's on her back or on her stomach. Okay. Do you see any? I don't want you to touch her. No. None. And there's a bunch of like welts and marks on her, and she looks stiff. But she does have goosebumps. I don't know. What's your name? Amy Robot. Can you spell the last name? R-O-B as in boy, A, S like Sam, S like Sam, E. And phone number, Amy? 319-217-2866. Okay, I'll get somebody over there, okay? Yeah, thanks. Okay. Yep, bye-bye. Hello. Okay, Amy? Yes. This is Sarah with the Iowa County Sheriff's Office. I've got an ambulance on the way, and I've got some deputies on the way. Where exactly are you guys at the Lily Lake? We're sitting at the pavilion. And the body is, there are 3 of us. There were 2 people walking, and I was actually just sitting in my car looking at the birds, and they came and grabbed me because they weren't sure if it was real, and so we're all sitting here together. Okay, just a minute. Yeah. Okay, so you said that she's on her stomach? She is on her stomach, yes. Does it look like she was in the water? No. Okay, and is there anything else around her? No, but there are all kinds of marks on her back. Like slashes. Okay. Okay, I'm wondering if there might have been no, we're not. We're not over there anymore. I'm wondering if there might have been a sexual assault too. Okay. Like I said, I have deputies on the way. If you could just Yep, we're waiting away from her, but if anybody does go to her, just tell them to get away, please. Yep. There's nobody else here right now. We're hanging out waiting. Okay, thank you, Amy. Okay. Yep. Bye-bye.
Yes, I did. No, it was not. Yes, I did.
Ross?
Thank you. Good morning.
Good morning.
Ms. Robas, do you recall what the temperature was that morning?
No, I do not.
You referenced noticing goosebumps, is that right?
Yes, I did.
That stood out in your mind that day?
Yes, it did.
You mentioned it today in your testimony. When you went home that day, you got on the internet, didn't you?
Yes, I did.
Some of the observations that you've made led you curious to learn more information, is that right?
Yes.
And so, for instance, you got online and you did a little bit of research on the internet about goosebumps, is that right?
That's correct.
But you're not an expert in that area, are you?
Absolutely not.
And you mentioned your observation of the knife injuries being possibly post-mortem, is that right?
Correct.
That is in no way an area of your expertise, would you agree?
Absolutely not. No.
You're just kind of guessing.
Correct.
That's okay. I appreciate it. You've answered my question.
Yeah.
I don't have any other questions. Thank you, ma'am.
Okay, thank you.
Redirect? Thank you very much.
Thank you.
You're listening to the Outcast Podcast. You're live on YouTube. Body Double Murder Trial.
Is the next witness likely to be a short witness or a long witness? All right, let's go ahead and take a morning recess then. We're going to be in recess for about 15 minutes. Jurors, have a good break. Please remember the admonition I gave you before. We'll see you back shortly.
You're watching day one of the body dumped murder trial here on the Outcast Podcast live on YouTube. Feel free to like and subscribe. I'm going to check and see what kind of a lead I have here. I have no buffer whatsoever. So we're just going to have to sit and wait for them to catch up to us. This is Outcast Podcast live on YouTube. And if you've been keeping up with YSL trial, as you know, Young Thug has uh, tweeted out. Everybody's tweeted out, but Jack and Stillwell, they're hearing right now. Outcast Podcast live on YouTube. I would be carrying YSL, but there's so many people carrying it right now. So I'm trying to find something people are not carrying. And it's the only thing I can find. So here we go. Powercast podcast here on YouTube. I think we're still waiting on them. I think they're in a break right this moment. They could be at lunch. I'm not sure. We're just waiting for them to come back. I don't have a buffer here. I was going to start 10 minutes before the trial started, and before I could get in and get set it up, they'd already started. They didn't even stick to their original start time. And I think it's because of that motion. But we're going to sit here and wait and see what happens. Outcast Podcast Live, YouTube.
You can all be seated. All right, we're back on the record in FECR 153477. Is the state prepared to call its next witness?
Yes, Your Honor.
You may do so.
State calls Mark Teat.
Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? I do. If you would please state and spell your full name for the record.
My full name is Mark James Teat. First name is M-A-R-K. Middle is James, J-A-M-E-S, and Teat is spelled T-I-E-D-T.
Thank you. Go ahead, counsel.
Thank you, Your Honor. Can you start off by telling us how you're employed?
I'm a deputy sheriff with the Iowa County Sheriff's Office.
And how many years of service do you have with the Iowa County Sheriff's Office?
I've been employed there since June 1st of 2006.
Are you a graduate, or did you graduate from one of the Iowa law enforcement academies?
I graduated from the 205th Basic Academy in July of 2005 at the Iowa Law Enforcement Academy.
And so does that make you a certified peace officer in the state of Iowa?
It does.
And you said your current position is deputy sheriff?
Correct.
Have you held any other positions through the Iowa County Sheriff's Office?
I was a canine handler for several years, but still a deputy sheriff during that time as well.
How many years were you a canine handler?
Approximately 7.
And did you have any law enforcement experience prior to becoming employed with the Iowa County Sheriff's Office?
Yes, ma'am. In 2005, I was employed with the Marion Police Department, and then I left there in October of 2005, approximately. I went to work for a family business, and then in 2006, I decided to get back into law enforcement. I worked briefly for the small town of Tripola Police Department, and then I got hired by the Iowa County Sheriff's Office.
And deputy sheriff, was that the position or the title that you held back in February of 2024?
Yes.
Can you tell us briefly, as a deputy sheriff, what your primary job duties or responsibilities are?
Mine differ a little than a normal deputy. I'm a patrol, primarily patrol, but I also assist with investigations when our primary investigator is overwhelmed or his caseload is too much or he's not available. But primarily it's patrol. You drive around, deter crime, traffic enforcement, answer calls for service, that type of thing.
Counsel, would you turn your mic on?
It is.
Oh, somehow it's not coming through well.
Will you
I'll turn it up.
Thank you. How's that, Judge? Better?
Thank you.
Deputy, on February 18th, 2024, did you become involved in a homicide investigation of Melody Hoffmanin?
I did.
And can you tell us how it is you became involved in that?
I was working just a normal patrol shift that day, and it was probably about 12, I think I have in my notes. In the morning, Iowa County Dispatch received a 911 call of a female that had been found at the Amana Lily Lake, and the caller believed that she may be deceased.
When you work patrol, are you patrolling the entirety of Iowa County?
Yes, all approximately 600 square miles.
Can you recall approximately where you were when this call came out from dispatch that this body had been found?
Actually, I was at the office. I was in Marengo at the time.
And so once that call came out, did you head straight towards the Lily Pond or Lily Lake area?
I did.
And just to be clear, Lily Pond and Lily Lake, are those used interchangeably?
Yes, it's very common to call it either one.
The information that comes in through dispatch, does dispatch then relay or tell you that information as you're responding to a scene?
Yes,
So you get that information, you're at the sheriff's office, and then you head to Lily Pond.
correct.
Do you recall approximately what time you arrived on scene?
I have it in my notes if I could refer to my report.
If referring to your report would help refresh your recollection, I'd ask you to look at that.
Okay.
Let me know when you found that answer.
I arrived on scene at approximately 10:23 a.m.
And can you recall what the weather was like that morning?
For February, it was warm, but I remember it was windy. And warm, I would say, for February, it'd be in the 40s, approximately degrees.
By the time you received this call, do you have any recollection of there being fog?
I don't.
Any memory of rain or any other types of precipitation that would have occurred late that night or early that morning?
Nothing is sticking out to me, no.
When you made your approach to the Lily Lake area or the Lily Pond area, what road did you come in off of?
I would have been on 220th Trail.
And I want to show you what's been previously admitted as State's Exhibit 2 with the court's permission to republish that.
You may do so.
One more. Thank you. Do you recognize this aerial photo of the Lily Pond area?
I do.
When you arrived at the Lily Pond area, which way did you come in from?
I would have came from the west traveling east. So this is 220th Trail here, and this is the direction I would have traveled, eastbound on 220th Trail to the Lily Lake, to this area right here.
And is that the area of the pond at the kind of center top of that pond area where the pavilion is located?
Yes, so this area right here, this would be the parking lot to the pond or to the Lily Lake, and then the pavilion would be right in here.
Thank you, Your Honor. When you arrived at that area, did you make contact with anybody?
I made contact, yes, with 3 individuals, and then also there was 2 QRS or first responders on scene already.
Okay, so the 3 individuals that you made contact with, do you recall their names?
One was Amy Robasi, and then I have Ursula Williams, and then her husband, Scott Williams, maybe. Yes, Scott Williams.
Was Ursula and Scott the older couple
Yes,
that was there with Amy Rabas?
correct.
Okay. You also mentioned that there were QRS members that were present. What's QRS?
In Iowa County, QRS is called Quick Responders. It's an acronym. And QRS is basically your first responders. So every town has volunteer service first responders. And this was called out as a medical call originally. So they dispatched an ambulance, but then they also dispatched first responders because the ambulance cannot get there as quick as first responders can.
Okay. And so these first responders have some degree of medical training or paramedics or something?
Yes.
Okay. So when you got there, QRS was already present?
2 members of the QRS was, yes.
And did they check Melody Hoffmanin for signs of life?
The one female member named Madison Frame did inform me she checked the Miss Hoffman for any heartbeat or anything like that, and she said she did not detect anything.
Is that typical for the medical personnel to arrive and make contact with the injured or deceased individual before law enforcement gets involved?
It is very common.
So after it was relayed to you or conveyed to you that Melody did not have any signs of life, what did you do next?
I went over and observed Miss Hoffman lying in the grass, and to me, obviously, she was clearly deceased as well.
When you say you observed her, can you describe for us what your initial observations of Melody Hoffman were?
So she was lying face down on the ground. Her head was to the east, her feet were to the west. Her arms were down to her sides, kind of spread out a little bit. I would say her hands were 2 or 3 feet from her body. She had all kinds of lacerations across her back and then some stab wounds on her back as well. Her underwear was pulled down over her buttocks, and then her bra had been pulled up towards her shoulders. She was not wearing any other clothing besides that.
Deputy, can you recall, or would you describe this crime scene as particularly bloody?
No, there was very little blood, actually. Miss Hoffman had a little bit of blood, but there was no blood pooled anywhere on the ground. To me, it was almost as if that's not where the scene occurred, the actual homicide occurred, because there was no blood anywhere, really.
Did you touch the body?
I did not. I did touch her body after the special agent with the DCI arrived and after the medical examiner. But prior to that, no, I did not touch her body.
So well into the investigation?
Yeah, yes.
Okay. At the time that you are there and making your initial contact, had this body in any way been identified?
No, it did not.
And so you noted that the medical examiner and you said an investigator, did they touch or manipulate the decedent in any way?
After they arrived on scene, yes, they did. We did move Ms. Hoffman to where we could take photos of her and examine her. But until then, no, Ms. Hoffman had not been moved.
In the course of events or the chain of events that occurs, photographs overall are taken, is that correct?
Correct.
Was the area and the condition of Melody Hoffman's body photographed before she was moved or manipulated in any way?
Yes, I did photograph the scene along with the body.
Can you recall approximately what time Melody Hoffman was confirmed deceased?
It was at 10:37 a.m.
Was the scene taped off?
Yes, it was.
Explain to us what it means to tape off a crime scene.
This area was rather large due to the open area, but basically we put crime scene tape, secured the parking lot. We put crime scene tape along the bike trail, and then to the east of the pavilion, there's actually a small bridge. We blocked the scene at that bridge with crime scene tape. And then we just basically kept everybody out of the scene that had no business to be in the scene. If someone had pulled into the parking lot, we politely asked them to leave the parking lot. We basically just kept everybody away from the scene.
How is it determined how big of an area to tape off when you're taping off a scene?
At this scene, we just started taping, actually. We just tried to get as much area as we possibly could taped off.
And though it may seem obvious, can you explain to us the purpose of taping off a scene area?
Just to keep the public and keep anybody outside that doesn't belong in the scene, to keep them outside of the scene and to preserve any evidence that is inside the scene.
So it limits contaminating the area?
Yes.
Okay. Once that area was taped off, did yourself and other law enforcement officers begin processing that scene?
We did.
And can you tell us what's the first step of processing a crime scene?
Photographing it, and which is what we did immediately.
When a crime scene is photographed, are there just numerous photos that are taken?
Yes.
And during that photographing process, was Melody rolled over so that her body could be photographed from all angles?
Ms. Hoffman wasn't rolled over until the medical examiner arrived, at which point we did roll her over. But yes, it was photographed after we rolled her over.
Once Melody was rolled over, did you make any additional observations that were relevant or pertinent to your investigation?
We observed more injuries on Ms. Hoffman.
What were the extent of those injuries?
You could see that where she appeared to almost have been strangled, like ligature marks on her neck and markings on her wrist and ankles as well.
Do you recall seeing any injuries to her face?
Just trying to think. If there was, they're not sticking out to me.
In the position rolled over, face up, do you recall seeing any blood?
If there was, it was very little blood, nothing that would stick out to me as being a large amount of blood.
Were there any evidentiary items that were located near or around Ms. Hoffman's body?
So we found a necklace that was laying near her, and we also found a piece of pink cloth that was laying near her. And I believe we found a cigarette and a blister pack for a pill. I don't believe we gathered those as evidence. I don't know if those had anything to do with the case or not. But those are the four things that stick out to me.
The necklace that was found, was she wearing that necklace?
No, it was laying on the grass next to her.
Do you specifically recall any pieces of jewelry being worn by Melody?
Ms. Hoffman did have a class ring on her hand.
Deputy, I would like to show you what had previously been marked as States Exhibits 6A through 6U. Are they on your screen, Judge?
Yeah,
Okay.
just on your screen.
Do you recognize these photos?
Yes, I do.
And are they photos that were taken at the scene at Lily Pond?
Those are all photos that I would have taken.
Okay. Your Honor, the state offers 6A through 6U.
Objection to Exhibits 6A through 6U. Exhibits 6A through 6U are admitted.
And may I have permission to publish photographs, Your Honor?
May do so. Tell me when you're ready.
I'm ready when you are. Deputy, starting first with States Exhibit 6A, can you tell us what we're seeing in this photograph?
So this area here would be the parking lot to the Lily Lake. This is a bicycle trail that goes all the way around the Lily Lake. This would be the pavilion, the picnic area for the Lily Lake. This is the shoreline, and right there is going to be Miss Hoffman's body.
And in States Exhibit 6B, can you tell us what we're seeing in this photo and from what vantage point?
So here, I'm actually going to be to the east of Miss Hoffman, looking back to the west. This is going to be Middle Amana, and this is going to be the Lily Lake. The pavilion would actually be over here on your right. It's out of the photo, and then there again is Miss Hoffman's body.
And 6C?
I'm actually going to be looking south across the Lily Lake, or southwest across the Lily Lake. This is going to be Whirlpool Manufacturing back here, the Lily Lake, and then this is going to be the shoreline. So I would actually be standing about where the pavilion, or right in front of the pavilion is where I would be standing.
When photographs are taken at a crime scene, is there an approach to taking those photographs where you start from a distance and work your way in?
Yes, so this one I did. I started from a distance. I took photographs of various angles, and then I slowly worked my way into the body,
What's the purpose of that?
just to try to catch any evidence that you may see, further away or further closer, just more to look for different types of evidence.
Does it also assist when you go back and look at photos to give you perspective on where things are?
Absolutely.
6D, what are we seeing here?
You're going to see Miss Hoffman's body. I would actually going to be to the northeast of her, looking at her body, and then this is going to be the shoreline to the Lily Lake right here, and then obviously the Lily Lake.
And 6E?
We're moving closer into Miss Hoffman's body. These items here, these are actually monitor pads that the ambulance put on her. But then we're just moving closer. So I'm standing to the east of her, taking a photo of her facing more to the west.
Can you tell us what we're seeing in 6F?
Yes, so this is just an overall view of Miss Hoffman's back and the slashing marks. She does appear to have some stab wounds, these 2 stab wounds here. And then there's this piece of pink cloth down here that we did gather as evidence as well.
The condition of Ms. Hoffman's undergarments, is this the condition that she was found in when you arrived?
Yes.
And the position of her body, was this the position that she was in when you arrived?
Yes.
And again, these blue and white items, one on the right shoulder, on the right rib area, and up on this shoulder, those were placed there by medical personnel?
Correct.
(6G).
Once again, it's just another overall view of Miss Hoffman, just from a different side.
From this angle or from this vantage point, were you able to observe?
Yes, here would be another one. So you have there's 1, 2, 3, and 4. And then those would be what I would consider a stab wound.
6H.
Just a close-up imagery of the back.
And though it may seem apparent, these straight linear marks on the body, those defects, were those wounds or injuries as well?
Yes, to me it would almost be like a slashing or a chopping or cutting type injury.
And earlier when you referred to slashing injuries, were these the injuries that you were referencing?
Yes.
(6I).
At this point, we're just taking photos of the stab wound here and using a tape measure for reference to show the size of the actual wound.
And so that tape measure gives you perspective on the size of that stab wound there?
Correct. And the same one here as well, just using the tape measure to show perspective of the size of the injury.
In 6J, because we're zoomed in, it's difficult to tell which part of the body this is. The black item here, is this the bra or underwear?
That would be her bra.
And 6K, what are we looking at here?
This is going to be her right hand. And the reason I took this is that the cuts on her fingers to me would almost be like a defensive injury, where she was holding her hands up or something. But the primary focus of this photo would be the cuts on her hand right here.
6L, what are we seeing in this photograph?
That is just going to
that was on Melody Hoffmanin when you came into contact with her. Is that ring present in 6L?
I believe that is the ring, yes.
6M, can you tell us what we're focused on in this picture?
It's kind of hard to see, but there's actually the injuries on her ankles here. And then,
Will you dim the lights for me, please? Does that help?
that does help. Thank
Okay.
you. The injuries to her ankles here. And then also you can almost see as if these lines here, and that's what we are focusing on.
What did those lines that you're referencing indicate
To
to you?
me, I mean, as if maybe her ankles had been bound at some point.
6N, can you tell us what we're seeing in this photograph?
That is just a homemade tattoo of a heart. I believe it's a heart. We used that, we photographed that because at this point in the investigation, we still had not identified her. So we were taking photos of any type of tattoos or anything that could help identify Ms. Hoffman.
Were there any injuries that you were able to also observe in the photo of 6N?
Yes, there's going to be these injuries right here around her hands. That to me appeared to almost as if her arms had been bound, her hands had been bound as well.
The darker mark just above that tattoo that you referenced, did that appear to be an injury, or was that just?
Yes, ma'am, that's also an injury.
What are we seeing in this photograph?
Here again, the injuries to the hand, and then to the arm and wrist, and then also the tattoo of the heart. But these are the injuries right here.
So this is the same arm wrist area that we saw in the previous photo, just from a different angle of the arm.
Yes.
6P, tell us what we're seeing in this photograph.
That is going to be the class ring that ultimately we use to identify who the female was.
And can you tell us how that ring was used to identify her?
Yes, so once we took the ring off, on the inside of the ring was the name engraved of Melody Hoffmanin, and we performed a record search through the Iowa driver's license system, and we were able to obtain a photograph of Melody Hoffmanin, and that is how we identified her.
$6Q, what are we seeing here?
This is going to be Miss Hoffman after we had rolled her over. This is just an image of her face.
Is there anything, well, what we see in the nose area, would that be blood?
That is a little bit of blood there, yes.
You also testified for us, Deputy, that when you rolled her over, you were able to observe additional ligature marks. Can you tell us where you saw those?
So they're actually going to be right in this area here. Here's a small one of them. I believe there should be more photos where I actually move her head a little bit and you can see those markings better.
And is that what we're seeing in 6R?
Yes, it's going to be these marks right here.
6S, tell us what we're seeing in this photograph.
That is going to be this small piece of pink clothing that I pointed out earlier. This is going to be her right breast, and then this is going to be her right arm.
In this photograph, is she still in a face down photo?
Yes.
And so when you see this and photograph it, is it also something that's collected from the scene?
Yes, that piece of pink clothing was collected.
$6T is a little difficult to see, but can you tell us what we're focusing on here?
Yeah, right here, it's very hard to see, but this is actually the necklace that we recovered at the scene. Here's one piece, one end, and then there's the other, and it goes in this shape right here. But that is going to be the necklace that we collected at the scene.
6U, is that the same necklace?
That is the same necklace. At this point, we had picked it up. I laid it on the paper bag and photographed it just so that way it could be seen better rather than in the grass.
While at the scene, did investigators add anything to her body?
No. We did put paper bags on her hands, but that was the only thing we did to the body.
Tell us why paper bags are put on hands at crime scenes.
To preserve any type of evidence that may be under her fingernails, any DNA evidence. Also preserves any markings that would be on her hands or anything like that.
And so the paper bags that are put on the hands, do those paper bags remain there until the time of autopsy?
Yes.
Can you tell us, once the scene was, the processing of the scene was completed, what happened to Melody Hoffman at that point?
She was transported to the state crime lab in Ankeny for an autopsy.
And the state crime lab in Ankeny, is that typically where autopsies are performed?
For our agency, yes.
Once the scene was cleared, Ms. Hoffman removed, did you perform any canvassing in the area?
I did. I went to spoke to a couple of the individuals that actually live across the Lily Lake in the middle Amana side.
And when we use the term canvassing, what's that mean?
I knocked on a few doors and just asked them if they noticed anything throughout the night or early in the morning that would be suspicious or that might raise alarm to them.
Through your canvassing efforts, was there anything that you gained that was important to your investigation?
No, nothing super important. The only one was I had spoken to an individual named Dan and Angela Ray, and they informed me that they are
Objection, hearsay.
Sustained.
The information that you got from the Rays, did you do anything with that information?
no.
Okay. So after having received it, did you make a determination that this wasn't essential to your investigation?
Correct.
Okay. I don't have any additional questions for this witness, Your Honor.
Cross? State can call its next witness.
State calls Corey Grote, Your Honor. Okay. May we approach, Judge?
You may.
Sorry.
All right, jurors, I'm told that our next subpoenaed witness is not subpoenaed until 1 o'clock. So we're going to take our lunch early today. Instead of lunching from 12 to 1:30, we're going to go from 11:30 till 1. And so I'm going to recess at this time. Please remember the admonition I've given you. See you back at 1 o'clock. Have a good lunch.
Outcast podcast here on YouTube. I had to step away from the computer for a second, so I'm going to bring this up and see if we're at lunch or what we're doing here.
State calls Corey Grote, Your Honor.
We just may be on the side for that one.
Subpoenaed witness is not subpoenaed until 1 o'clock. So we're going to take our lunch early today. Instead of lunching from 12 to 1:30, we're going to go from 11:30 to 1. And so,
Okay, so we're going to lunch.
Please remember the admonition.
All right, so we are not back till 1 o'clock here. So I'm going to go ahead and just leave the stream up. I'll go in here and put quarters on break. And I will see y'all back here at 1 o'clock. Outcast Podcast live on YouTube.
All right, so listen up. State Farm was trying to charge me $197 for car insurance. No, thank you.
The bowl got knocked over, but off the tail.
Let you know.
Outcast Podcast, we're waiting for it to return. They're supposed to return at, I'm not sure what time. They're supposed to return, to be honest with you. Waiting for them to return. This is the Outcast Podcast coming to you live right here on YouTube.
Meet Tello, your great alternative to Lifeline discounts. It's time to experience a new way to save money and enjoy.
At Cyber Academy of South Carolina, we know your child is one of a kind, and their school should.
Are you a certified peace officer in the state of Iowa?
Yes.
You reference yourself as a sergeant detective. Are those two different titles?
Detective is what I'm assigned to do. Sergeant is my ranking.
How long have you been a sergeant?
Since 2016.
And can you tell us what it takes to be promoted into the sergeant's position?
It's up to the command staff.
Was that an interview process?
Yes.
Do you need a certain educational background?
I know they've changed it over the years. I think it's either I think it's a 2-year degree.
What's your educational background?
I attended the University of Northern Iowa and graduated there with a bachelor's degree.
And then you said you were assigned as a detective.
Correct.
Okay. Is there a specific, the word that's coming to my mind is bureau, but is there a specific set of crimes that you do detective work on, or?
No, we're just assigned zones. The county's split up into 4 zones. So whatever crimes happen in our particular, each detective zones, we're responsible for those crimes.
What zone are you assigned to?
Zone 3.
And what area does that cover?
It's the southwest portion of the county. It would include Palo, Fairfax, and Walford.
Has that always been your zone?
Yeah.
Detective Grote, did you become involved in the homicide investigation of Melody Hoffmanin?
Yes.
And when you became involved in that, was that in your capacity as a detective?
Yes.
When did you become involved?
On February 19th of this year.
And tell us how that came to be.
I received a phone call about 1 p.m. in the afternoon that day from my supervisor, Lieutenant Dave Buter. He had informed me that a deceased female had been located in Iowa County, and that they had information that she had possibly been in Morgan Creek Park. He asked that I go there along with a couple other detectives to check the area for any evidence that could be related to that case.
So after you received that call from Lieutenant Buter, did you then go to Morgan Creek Park?
I did.
Is the Morgan Creek Park that you're referring to in Lynn County?
Yes.
Was there a specific area within the park that you were asked to focus your attention on?
It was I believe it was the first parking lot, just as you come into the park off of E Avenue Northwest.
Do you know why you were asked to focus on that specific area?
Just very generally speaking.
Okay.
Basically, they had maybe location data from some type of device that belonged to the female victim, was the way I understood it. And that's where it showed that it was at.
And so when you arrived at Morgan Creek Park, did you start your search of that first parking lot area?
I did not. I drove past there and just kind of did a overall drive. It's kind of a large driveway area. There's a number of different like separate parking lots. And then I eventually came back to that first parking lot that they were referring to. And I think when that happened, Sergeant Eric Lear was there, and then Sergeant Tim Payne was there as well.
When you went down this, I think you described it as like a long driveway into the park, were there areas down and along that driveway or other areas of the park that you also searched?
Yeah, there's a large playground area, a large pavilion. There is, like I said before, multiple different separate parking lots. And then there's also a off-leash dog park there as well.
Can you tell me or tell us when you were doing the search of these areas, what's the search entail? What's it look like?
We were just looking for anything that may be connected to the victim in Iowa County. So basically anything that could look out of place, or maybe some blood evidence or clothing, or pretty much anything, personal belongings.
I know you named a couple of other sergeants that were involved. Do you recall how many of you were out there doing that?
There's 3 of us.
And approximately how long did you guys spend doing this search?
Probably 2.5 hours, somewhere in between 2 and 3 hours.
Was there anything of evidentiary value found at the park during this search?
No.
While out in that area, did you attempt to locate surveillance cameras or anything of that nature?
So that's a newer area, I think, within the past couple years, but they do not have any cameras at that location.
So you did attempt to find out if there were surveillance cameras?
Yeah, I was already aware from previous investigations that the new playground park area does not have surveillance cameras.
Where'd you go after you left Morgan Creek Park?
Sergeant Payne and myself were then asked to go to the Walmart on the southwest side of Cedar Rapids. I think he had sent Tim Payne a couple of receipts that were located in a suspect vehicle during a search warrant.
And those receipts showed purchases made from the southwest side Walmart?
Correct.
Were you guys in possession of or sent at some point copies of those receipts to take with you out there?
Yeah, I think that came through through a text message.
So then did you go straight to Walmart from there?
As I recall, yeah.
Who'd you meet with at Walmart to assist in this part of your investigation?
It was the loss prevention employee, Tyler Heggie.
And did you ask Tyler to help you collect or find surveillance video from within Walmart at the time that correlated with those receipts?
Yeah, we would have provided him, either shown him the receipts or provided him the date and time of each transaction.
The first receipt, and I say first chronologically, but what was the date on the first receipt?
It was February 17th at 2:56 p.m.
2024?
Yes,
And so you say at 2:56 p.m., so the receipt also had a timestamp on it?
correct.
Can you recall, or do you have recollection of what was purchased during that February 17th, 2:56 p.m. trip?
I didn't at that time. The description, from the description, I couldn't tell what it was, but I later found that it was a digital doorknob.
And when you reviewed the video from the date and the time that was stamped on the receipt that was recovered, were you able to see who was making the purchase?
Yes,
And who made the purchase of that digital doorknob?
it was the defendant, McKinley Louisma.
And just to be clear, is he in the courtroom today?
He is.
Can you point him out, describe an article of clothing he's wearing?
It's the gentleman sitting in the light blue long sleeve button-up shirt.
Your Honor, if the record could reflect, this witness did identify the defendant.
It will.
The second receipt, chronologically, when was it dated and time stamped?
February 17th at 22:06 or 10:06 p.m.
And was the loss prevention employee, Tyler, was he also able to assist in pulling video from the store at the time of that purchase?
Yes.
Did you view those videos?
I did.
Can you tell us what you observed from those videos?
For both of them?
For the videos related to the 10:06 p.m. purchase.
Okay. So there were 4 videos. One would have been at the in the parking lot, showing the vehicle of the 3 people that were related to this specific transaction. Then there was an overhead shot at the self-checkout showing the purchase itself and the 3 individuals who were there. And then there was 2 other clips up at the front of the store, so past the point of sale registers, 2 different clips of them leaving or exiting the store.
And so when you're discussing these different clips and the location of these cameras, there were multiple cameras that were recording simultaneously during this time.
Correct.
And those different cameras would pick the defendant up throughout the store.
Yes.
Were you able to ascertain from your review of these different camera angles what the defendant was shopping for or what purchases he made in the store?
Yes, for that evening purchase at 22:06, it was for 2 machetes and 2 pairs of coated gloves.
And what's a coated glove?
I believe it's just a nylon glove that has kind of maybe a rubber coating.
And you saw that on camera?
Yes.
Did you also confirm that with the itemized list of items on the receipt?
Correct.
As you were viewing these different camera angles on the surveillance, were you able to take some screenshots from those surveillance videos?
I did not take any screenshots. I believe it was probably somebody with the Marion Police Department. We just forwarded the video in its entirety, the video clips, to the Marion Police Department.
Okay. Have you, since having retrieved the videos, seen the screenshots that were taken from the surveillance videos that were collected?
Yes.
Okay. Your Honor, at this time, I would like to show this witness State's Exhibits 7A through 7P, please. And I'm just going to go through them quickly, Detective Grote. Do you recognize these photos from the surveillance video that was collected?
Yes.
And were these screenshots of video that was taken on the 17th of February, 2024?
Yes.
Your Honor, the state offers 7A through 7P.
Any objection to 7A through 7P? Exhibits 7A through 7P are admitted.
And may the state have permission to publish those exhibits, Judge?
You may.
Detective Grote, firstly, I want to there's a laser pointer up there if there's something that you want to draw our attention to.
Okay.
In State's Exhibit 7A, can you tell us what we're looking at in this photograph?
This is the sporting goods section at the Southwest Side Walmart. The 3 individuals on the clip, the one with the stocking cap, the white male with the stocking cap on the right side is Dakota Van Patten.
Would that be this person?
Yes.
Okay?
The subject to his right is Logan Kimpton, and then the male directly behind him is McKinley Louisma.
And in 7B, what are we seeing here?
McKinley Louisma?
Is that the same aisle that was seen in the previous exhibit?
Yes.
And in 7C, what are we seeing?
Dakota Van Patten?
7D,
The same three individuals. The first one, Van Patten, then Kimpton, then Louisma.
and in State's Exhibit 7E, what camera angle are we looking at here?
So this is above the self-checkout register.
And are you able from this angle to recognize the parties shown in this photograph?
I can, just because I've reviewed the video clip.
Okay, who is the person in the bottom right-hand corner?
McKinley Louisma?
And the person in the middle, is this just a Walmart employee?
Correct.
And whose shoe and hand in a pocket is seen on the left bottom side of this screen?
I believe that's Dakota Van Patten's.
Excuse me. 7F, can you tell us what we're seeing here?
The purchase for the two machetes, there's two machetes there, and then the same three individuals.
The person seen in the middle now, who is this?
Kimpton, Logan Kimpton.
And in 7G?
So that is Logan Kimpton's right hand inserting a $20 bill.
After you had an opportunity to review the video, did the $20 bill come out of the defendant's wallet?
Yes.
And in 7H, is this the second machete that was being purchased? As the other one's in his left hand?
Yes.
Speaking of 7H, there were items seen in this gray bag. Were those items selected from the store by the defendant or the two others that were with him?
No.
How did they get in that bag?
We had gone back to Walmart the second day for a few other things and were asked by Marion investigators to inquire as to how those two items got in the bag. In reviewing the video at the store, there was a Walmart associate who was at the register just prior to this transaction. It appears that she rang those two items up and then got distracted by either a text or a phone call on her phone and walked off, leaving, I believe, like a flavored water and a box of cookies in that bag.
And 7I, what are we looking at here?
That shows McKinley Louisma holding both machetes, and he has his wallet out, I believe. I take that back. I think those are the coated gloves in his left hand.
And in 7J, are you able to confirm that in his left hand it is the coated gloves?
Yes.
What are we seeing in 7K?
They just left the self-checkout. McKinley Louisma has the gray sweatpants, dark colored hoodie, and red shoes. And then to the left, individual with the stocking cap on is Dakota Van Patten, and the subject that you can barely see is in front of him is Logan Kimpton.
And the three individuals that you just referenced, are they also shown in 7L?
Yes.
Shorter one is Kimpton,
Yes.
stocking cap, Dakota Van Patten,
Yes.
and this gentleman to the left with the red shoes is Louisma.
Yes.
And in 7M, is that a continuation of them leaving the store?
Yes.
Who's carrying the machetes in these photographs?
McKinley Louisma has the bag.
And the two long items, are those the machetes?
Correct.
When you say that McKinley Louisma has the bag, did that bag when they left also contain that flavored water and that package of cookies?
Yes.
7N, what camera angle are we seeing in this photograph?
It's the parking lot.
Same three individuals?
Yes.
On the left, is this Dakota Van Patten?
Yes.
And is McKinley Louisma the subject on the right?
Yes.
And then Logan Kempton in the middle?
Yes.
And in 7-0, what are we seeing?
They're getting into a dark colored sedan.
When you say dark colored, are you able to tell what color that vehicle is?
It looks blue.
May. Go ahead.
I think we talked about 7-0. I'm going to move on to 7P. Same people, same car in the same parking lot.
Yes.
Was there anything, will you clear my screen, Judge? Other than being tasked with searching of the Morgan Creek Park and the collection of videos and investigation done with the videos at the Southwest Walmart, was there anything in addition that you did as part of this investigation?
We went to a couple other places to try to obtain video.
So just some canvassing?
Yeah.
Okay. And to be clear, was there any video found at those other places that you went to that was relevant to your investigation?
We had gotten a video clip from the BP in Walford of a dark colored sedan that looked similar to the one at Walmart from that evening purchase, but that was all.
The BP that was obtained from, was that BP selected because it was on the path to the Lily Pond area?
Correct. I had gotten information, or one of the detectives had gotten information from the Marion Police Department and specifically wanted us to check that BP.
I don't have any additional questions, Judge.
Cross-examination.
Thank you. Good afternoon, Detective.
Hello.
Let's go back and talk about your work at Morgan Creek Park, please, okay?
Okay.
You went there and arrived at sometime in the afternoon, is that right?
Yeah, it would have been shortly after 1 p.m.
Daylight.
Yes.
Your information was that Melody had been there very early that morning, is that correct?
I don't remember receiving a specific time.
And you were directed to concentrate on a particular parking lot, is that your recollection?
Yes.
You were looking for anything that may have evidentiary value?
Correct.
You were not the only one searching, correct?
No, there was 2 others.
3 total.
To my recollection, yes.
Now, do you recall, let's say from midnight that morning until when you were there in the afternoon, had it rained?
I don't recall.
Had it snowed?
I don't know.
You spent 2.5 to 3 hours searching that area?
Approximately, yeah.
And you didn't know exactly what you were looking for, correct?
Correct.
But one of the things you mentioned keeping an eye out for was blood, is that right?
Yes.
In the hours that you 3 were out there, you did not locate anything that appeared to be of evidentiary value, is that correct?
Correct.
Thank you, Detective. Nothing else.
Redirect.
Just briefly, Your Honor, I want to, Detective Grote, ask you just a couple more follow-up questions about that video scene from the BP gas station.
Okay.
When you saw the blue sedan at the BP gas station, did that vehicle ever stop at the BP?
If it did, it was very brief. It entered the parking lot, pulled up to one of the the first gas pump that it came to, and then it kind of slow rolled and then left.
No one ever got out?
No.
And when you were watching the video clip from the BP with that blue sedan pulling up, slow rolling, driving off, was there any, did you see any law enforcement vehicles or officers visible in that video at the time?
No.
I don't have anything else, Judge.
Cross.
Nothing else. Thank you.
Thank you.
Thanks.
State can call its next witness.
Your Honor, state calls Trevor Weiss.
Would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
If you would please start by stating and spelling your full name for the record.
Trevor Weiss, Trevorweis.
Thank you. Go ahead, counsel.
Mr. Weiss, how are you today?
I'm doing well. How are you?
Good, thanks.
You're welcome.
Appreciate you being here. Can you tell us a little bit about yourself? First of all, how old are you?
I'm 30. July 8th of 94. I was born in Cedar Rapids, Iowa. Born and raised here. I work at Lebowski's in Robbins, Iowa. I live in Tower Terrace Trailer Court. I got a dog. Spend most of my time with him. Other than that, work, sleep, and take care of the dog.
All right. Dog's name?
Dash.
What kind of dog is it?
Black Lab mix.
So just you and your dog live at the
Yes, sir.
trailer? What's the address of that trailer you guys?
2728 Morning Dove Lane.
What city is that in?
Hiawatha, Iowa. 52233.
What's the name of the trailer park?
Tower Terrace Trailer Court.
How long have you lived there?
I've been there for a year.
You said you work at a place called Lebowski's, and I think you're wearing the gear right now, right?
Correct. Yes, sir.
Tell us about Lebowski's. What's that?
It's a bar and grill in Robbins. I've been there 4 years. I'm a cook. I make food for the people of the surrounding area, and that's about it.
You been a cook the whole time you've been there?
Yes, sir.
What kind of hours do you work?
I work mainly night. Monday, Tuesday, I work from 3:30 to 8 o'clock-ish on Monday. And Tuesday, I work from 5 to close. Wednesday, Thursday off. Friday, I work during the day. Friday is 11 to 4. And then Saturday's 5 to 11. And then I work all day Sunday from 10 to about 8 o'clock.
How many hours does that add up to?
I mean, bi-weekly, it's about like 32, 35. And on a 2-week check, it's about 62, 65.
Is that pretty much the standard hours that you work then weekly?
Yes, sir. My schedule doesn't change and it hasn't changed.
Have you always been a cook out there?
Yes, sir.
What's the best thing to get at Lebowski's?
The dude fries.
No. Were you working at Lebowski's back on February 17th and 18th of 2024?
Yes, sir.
So February 17th was a Saturday, is that right?
Correct.
Okay. What shift were you working that Saturday?
5 to 11.
Is 11 o'clock basically close time?
It is close time, yep.
Shifting gears a little bit, do you know a gentleman by the name of McKinley Louisma?
I don't know him by McKinley, but I know him by Ken.
Okay. Do you see Ken in the courtroom today?
I do, sitting right there.
Could you describe what he's wearing?
He's wearing a blue shirt, wearing black pants.
Did the gentleman over here by his attorneys?
Yes, sir.
May the record reflect a witness identify the defendant, Your Honor.
It will.
Trevor, how would you describe your relationship, if any, with Ken back around February 17th of 2024?
I met him through my mom, which she lived right around the corner at the time. He was just a ride to work. He'd come pick me up. He'd drop me off. Basic to minimal communication, nothing out of sort.
Said you met him through your mom. Who's
Correct.
Your mom?
My mom is Patricia Bascom.
Trevor, sometimes when I ask questions, I pause a little bit before I'm done. So if you don't mind, kind of wait until I finish. I'll try to do better at that.
Okay, sounds good.
We'll talk over each other. Where's your mom live?
She lives out by Prairie now, but she moved from that address.
Did she live out by you in that trailer court back in February?
Correct.
And who did she live with?
Alan, which is her boyfriend, and that's about it.
At some point in time, was the defendant living over there with her?
Yeah,
Staying
Ken
there?
and his girlfriend at the time.
Remember his girlfriend's name?
I do not.
So round about February 17th and 18th of this year, was Ken and his girlfriend also living with your mom, Patty?
Correct, yeah.
Remember the name of the street they lived on?
It's right around the corner. I don't remember.
Is there a Hummingbird Lane out there?
Yeah, it's right around the corner. Yep, Hummingbird Lane.
Do you know a gentleman by the name of Logan Kimpton?
That's my nephew.
So if he's your nephew, then would he be Patty's grandson?
Correct.
Did he also live there or stay there at the time?
He was bouncing back and forth. I didn't really keep too much tabs on him.
Did you have any contact with the defendant on the evening of February 17th, 2024?
Yeah,
Can you tell us how you came into contact with him?
I needed a ride home from work, and he came and picked me up. So after I got off, I got in the car with him. He drove me from Lebowski's. We went down the main street there in Robbins. Then we went over the bridge and took a left on Robbins Road. And then as soon as went down a little ways, then took a right onto Tower Terrace, and then went straight from there, and then the roundabout, and then straight, and then took a right onto Morning Dove, and then dropped me off.
How long a ride is that?
It's about 8 minutes car ride.
How did you arrange for him to pick you up that night?
I messaged him. Yeah.
Was he agreeable to give you a ride?
Yes, sir.
Is that something he would do for you on occasion?
Yes, sir.
Do you remember approximately what time he picked you up or arrived at your workplace?
About 10:30.
You said 11 o'clock was closed, right?
11 o'clock is closed, yep. But he arrived a little early, 10:30, 10:45-ish. And I got done around 10:58 that night.
You said was there somebody with the defendant?
Yes, sir.
Who was that?
Dakota Van Patten.
When the defendant and Dakota Van Patten arrived at Lebowski's to pick you up early, did you make contact with him and tell him that, you needed more time or anything like that?
No, I just finished up my work and got my work done, and then got a ride home.
Did you know Dakota Van Patten before that day?
I did, but it was minimal communication before then.
Where
I
had
met
you
him
seen
through.
Sorry.
No, go ahead.
Where had you seen him before?
My mom's house on Hummingbird Lane.
Did you recognize him at first?
I did, yeah.
Did you figure out that the two of you, and that's you and Mr. Van Patten, that you had met before?
It took me a while, but yes, I did. I did, yeah. I met him through his brother.
Who's his brother?
I forgot his brother's name.
Do you recall sometime around this time period you received a request on Facebook, what we call a friend request from Dakota?
Correct.
And is that something that you still had on your phone and had on your phone to provide law enforcement?
I believe so, yeah. I didn't accept it at all.
Your Honor, may I show the, one second. Before I get to that, Trevor, when you got into the car to get a ride home from Lebowski's, do you remember where you sat in the car?
I sat in the behind the passenger.
And when you sat behind the passenger seat, then did you have to maneuver your way into the car to get in there?
No.
Okay. Open the door, go in the car?
Just open the door and get in and close the door.
Okay. And it was the passenger side back or the
Passengers. It was a passenger side back, behind the passenger, because there was somebody sitting in the passenger, driver, and then I got behind the passenger in the back seat.
Okay. And who was driving?
Ken was
Where was Dakota sitting?
passenger, front seat.
Your Honor, may I show the witness states exhibit number 8A and 8B for identification? Trevor, do you see states exhibit number 8A?
Correct.
Do you recognize that exhibit?
I do.
Okay, and then I'll show you states exhibit 8B. Do you recognize that exhibit?
I do.
And what do these exhibits contain?
A friend request from Dakota.
Okay. Is that a fair and accurate depiction of the friend request as it appeared on your phone from who you learned to be Dakota Van Patten?
Correct.
Move to enter states exhibits 8A and 8B, Your Honor.
Any objection to 8A or 8B? Exhibits 8A and 8B are admitted.
Trevor, in front of you, we have states exhibit number 8B first. Can we publish that, Your Honor?
You may.
Thank you. And what does 8B then depict?
If I need to respond to their request or not.
Is this what's depicted in states exhibit 8B? Is that your phone?
Correct, yeah.
Okay. And is this what is referred to as like a profile page for Facebook?
Correct.
Is this the profile page of who's described as Coda Smith, but you learned to be and knew as Dakota Van Patten?
Correct.
And this is the way it appeared on your phone when he sent the request and you looked to see who it was?
Yes, sir.
Okay. Now I'll show you states exhibit 8A. Okay. And what is depicted in states exhibit 8A?
Profile picture.
Is this maybe the close-up or what happens when you tap on the profile picture of Coda Smith?
Yes, sir.
And is this the same person who was in the car when Ken, the defendant, picked you up on February 17th, 2024, known as Dakota Van Patten?
Yes, sir.
Okay, thank you. Thanks, Judge. So during that 8-minute car ride, do you remember anything about the conversation that took place?
I remember when we got to like Tower Terrace Road, and then we came up and saying that that don't tell my mom, but they're trouble together, like hanging out, Ken and Dakota. That don't tell like my mom like that they're together.
Wait. You have to have your mic. You may. So I think where we left off, though, counsel, you had stated an objection. My understanding is that counsel was going to try to clear up the matter, and then you'll restate the objection if appropriate. Go ahead.
So we were talking about a conversation that took place in the car, Trevor.
Yeah.
And you were starting to tell us about that, but Before you do, I wanted to ask you, who was talking or telling you about the two of them, that's Ken and the defendant, Mr. Van Patten, being together? Who was talking at that time?
Ken.
Okay. So when the defendant was talking about being together with Mr. Van Patten, did he tell you not to tell your mom that?
Correct.
And did he tell you why?
Please approach. Objections overruled.
Trevor, did the defendant tell you why he didn't want you to tell his mom that he was with Mr. Van Patten?
That I didn't want to tell my mom?
Yeah.
Because they would get in trouble together.
Anything else happen during that car ride?
No, it was a pretty smooth car ride, sir.
Did you have contact with the defendant, Mr. Louisma, again after he dropped you off at your house?
Not again after until the morning after. It was a Sunday morning. About 8:30, came knocked on my door, knocked on my window.
Okay.
Finally go ahead.
And then what were you doing when he came to your house and he knocked on the window?
I was sleeping.
Did that wake you up?
Yes, sir.
And when you heard the knocking, then did you do something to see who was there?
I did.
Okay. What'd you do?
I then waved him over, come to the door. And then I opened my door. He stood right in the landing area of my front, like in front of my house. And then then he was like, if somebody approaches you, ask you questions, just tell them I was here all night playing video games. And it was kind of, raised questions in my mind.
So he told you that if someone asked to say that he was with you all night playing video games?
Correct.
Okay. And when he said that to you, did you tell him anything?
No, I just said that he had to go, and then he proceeded to leave.
You see where he went?
He went back to my mom's.
You said that happened about 8:30 in the morning, then the next morning on Sunday?
Correct.
I have no further questions, Your Honor.
Cross-examination.
Thank you. Good afternoon, Mr. Weiss.
Hi, how are you doing?
I'm well, thank you.
You're welcome.
Let's talk about this 8-minute drive from work to home, okay?
Okay.
You'd only known Ken, my client, for about 2 weeks on that night, is that correct?
Correct, yep.
He'd given you rides to or from work before?
Correct, yep.
And so this night was not unlike any of those other nights, agreed?
Agreed.
Took you about 8 minutes to get home?
About.
You were anxious to get home that night, weren't you?
I was ready to get home, yeah.
And so you were kind of thinking about how you were looking forward to getting home, weren't you?
Mm-hmm.
Is that a yes?
Yes, sorry, yes.
That's okay, thank you.
You're welcome.
And when you were in the car, there was conversation among all of three of you, correct?
Correct.
Now, today, your testimony was that during that 8-minute car ride, Ken said, don't tell your mom, correct? Is that right?
Correct.
And that he went on to say, don't tell your mom because he and Dakota tend to get into trouble together. Is that right?
Correct.
Now, you and I have talked about this 8-minute car ride before today, haven't we?
I believe so.
At your deposition?
I believe so, yeah.
That was On July 25th of this year, do you recall that?
I do. Yeah, I do. Yeah,
It was here at the courthouse, is that right?
I believe so. Yeah.
And you were under oath,
Yes.
and we had a chance to talk about this just like we are today. Would
Yeah.
you agree?
Agreed.
And this conversation in the car came up during our deposition, didn't it?
I believe so.
Have you had a chance to review your deposition transcript before today?
I have not. No.
So today, it was your testimony that Ken said, "Don't tell my mom because we get into trouble," correct?
Correct.
But that's not what you told me in your deposition, is it?
I don't remember.
Would it help you if you had a chance to look at that transcript?
Yes.
And counsel, and for the record, this is page 21, starting at line 20. May I approach, Judge?
You may.
Mr. Weiss, I'm going to set this in front of you
Okay.
and give you a chance to read it. Please just read it to yourself, not
Okay.
out loud. Read as much as you need to remember this.
All right.
And I'm going to direct your attention to line 20, okay? Because I may ask you a question next, I'm going to ask you to keep reading into the next page, again, just to yourself. Do you have a chance to review that?
I did.
Well, your testimony today was that Ken said that they got in trouble together. That is not what your testimony was in your deposition, was it?
Correct.
In your deposition, you said that was simply your impression
Yeah.
from what had been said, correct?
Yeah.
And actually, in your deposition, you said, "I don't even remember who said that to begin with," correct?
Correct.
Thank you, Mr. Weiss. I don't have any other questions.
All right. Thank you.
Thank you.
Redirect.
Thank you, Your Honor. Trevor, you just showed a copy of your deposition.
Correct.
And at the time you gave the deposition, remember when that was?
July 25th.
As you sit here today and you were answering questions under oath, did you remember who it was that said that in the car?
I don't remember exactly, but I haven't really been feeling too well.
Well, today, when we asked you, you said it was McKinley that said that.
Yeah.
As you sit here today, do you remember him saying those words?
I don't know.
At the time that this exchange took place, who was living with your mom?
Who was living with my mom?
Yeah.
Well, my mom's boyfriend and just her that I know of, and then Ken and his girlfriend were staying there.
And did Dakota Van Patten, to your knowledge, ever live with your mom?
No, sir.
Other than being at your mom's house when you met him once, do you know if Dakota Van Patten knew your mom at all?
Well, I would assume so if he knew my mom that they were over there. Yeah.
In prior conversations with Dakota Van Patten, did he refer to your mom as in this way at all? Talk about don't tell her something, things like that?
No, sir.
That's all I have, Your Honor.
Rick Cross? Thank you, sir.
All right, thank you.
State can call its next witness.
State calls Jan Abel, Your Honor.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your full name for the record.
My name is Jan Abel, Yonabel.
Thank you. Go ahead, counsel.
Thank you, Your Honor. Will you tell us how you're currently employed?
I am a detective sergeant with the Lynn County Sheriff's Office.
And how long have you been employed with the Lynn County Sheriff's Office?
28 years.
Certified peace officer in the state of Iowa?
Yes,
Did you have any law enforcement experience prior to becoming employed with Lynn County?
I did not.
And what's your educational background?
Received a Bachelor of Arts in General Science from Coe College in 1995.
Your current role is detective sergeant. Was that also your role in February of 2024?
Yes,
And when were you assigned to be a detective?
2011.
You said 11?
2011, correct. 13 years.
Detective Abel, did you become involved in the death investigation or homicide investigation of Melody Hoffman?
Yes.
And can you tell us when you became involved in that?
Would have been Monday, February 19th.
And how did that involvement come to be?
I was notified by my supervisor, Lieutenant Buter, to attend a meeting at the Marion Police Department involving a homicide investigation.
And did you go to that meeting at the Marion Police Department?
I did.
From there, were you directed to go to the Lebowski's Bar and Grill?
Yes.
And what was the purpose of going to Lebowski's?
Purpose was to talk to Trevor in regards to his involvement with a suspect.
And so did you go to Lebowski's?
I did.
And did you meet with Trevor?
Yes.
Now, while you were at Lebowski's, did you conduct an interview with him there?
We spoke to him briefly, and then we agreed to meet later at his residence.
And can you recall the address that you initially intended to meet Trevor?
I do not know the exact address.
Did you eventually interview Trevor?
Yes.
And did that interview later happen at Trevor's mother's place?
Yes, we met with him first at his mother's house.
And that was on the, or at the Hummingbird address?
Yes.
Do you recall if Trevor's address was Morning Dove?
Yes.
Okay. So did you expect to run into Trevor at the Hummingbird address?
I did not, but I was not surprised when I did.
Through your investigation, were you able to determine who all resided at 4006 Hummingbird?
I know Trevor's mother resided there, and then I know there was two other people that had been there for a couple weeks, but beyond that, I was not involved in any of those interviews.
How did it come to be that you were at the Hummingbird address?
There was other law enforcement personnel there, and we went there to see if we could assist.
with whatever may be needed at the time.
Was there a search warrant being executed at that address? Can you recall?
I believe there was, but I'm not certain on that.
While you were interviewing Trevor, were you able to confirm whether or not he had been at work on Saturday, February 18th?
Yes,
17th, excuse me.
Saturday the 17th.
Okay. And were you able to confirm what hours he worked that day?
Yes,
What were those hours?
I believe it was 8 to 5. I know he had a printout of his time card that he was able to provide to us for that date.
When you were interviewing Trevor, did you discuss with him how he got home from work
Yes,
on the 17th?
yes.
Okay. And did he tell you he got picked up from work?
If you have my report available to review, I know he says sometimes he walks, sometimes he gets rides from coworkers, or it varies day by day.
Do you recall asking him a line of questions about who was all in the vehicle when he was picked up?
Yes.
Okay. And during that conversation, did he and you discuss somebody, I'm going to call it a Facebook name, Dakota Smith?
Yes.
Did Trevor show you his phone and let you take photographs of his phone?
Yes.
Were you able, through your investigation, to determine who Dakota Smith is?
The URL or web address actually said Van Patten for a name. So the Dakota Smith was the name that was on the account,
But Dakota Van Patten was the web address that was associated with that?
yes.
Also, as part of your role in the investigation, were you asked or requested to do some follow-up work, excuse me, at the Southwest Walmart?
Yes.
Can you tell us what the purpose of you doing that follow-up work was?
I went to Walmart to take photos of an aisle in the sporting goods area, and specifically items that were purchased from that location.
How did you know which aisle in the sporting goods section you needed to go photograph?
I'd seen video previously of people in that area before, coming from that general area, and I knew what items I was looking for as well.
What items were you looking for?
I was looking for a machete and then also a pair of gloves.
And when you got to the Walmart and got to that aisle, did you determine that the machetes and the specific pair of gloves you were looking for were in the same aisle?
Yes,
And did you photograph all of that?
I did.
Your Honor, the state would offer 9A through 9H.
Any objection to 9A through 9H?
No objection.
9A through 9H are admitted.
May I have permission to publish States Exhibits 9A through 9H and to republish Exhibit 7B?
You may. Tell me when you're ready.
I'm ready, Judge. Looking first at State's Exhibit 9A, is this the sporting goods aisle that you were primarily focused on?
Yes.
Along that back shelf there, what are those?
Coolers?
And to show you State's Exhibit 7B, are those coolers at the top of the screen along that back row as well?
Yes.
From this vantage point in 9A, where are the machetes hanging in this aisle?
Be on the right side.
And is that in this area?
Yes.
And the gloves that you were looking for, where were those hanging?
On the left side.
In this area?
Correct.
So in State's Exhibit 9B, have you now turned your camera to the right of that aisle?
Yes.
And were you able to see or find the specific machetes that you were looking for?
Yes.
And is kind of center screen, is this the machetes that you were looking for?
Yes.
Did the machetes that were hanging on that rack match up with the machetes that were found in this investigation?
Yes.
And when I say match up, packaging, size, shape, all of the above.
Yes.
Is 9C a closer up photo of the machete that I just circled with my mouse in the prior photo?
Yes.
And 9D, what are we looking at here?
It's the opposite side of the aisle. We're looking at fishing and gloves specifically.
Do you want to use that laser pointer that's up there, please, and on the big screen, show us the gloves that you were specifically looking for?
So it'll be these gray and black right there.
The gray and black ones that have writing on the top of the hand?
Yes.
And are we zoomed in on those gloves on 9E?
Yes.
Just to be clear, out of the two gloves that are shown in 9E, are we looking at the ones on the left?
Yes, the ones with the $277 price tag above them.
Perfect. 9F, what are we looking at here?
This will be the same glove reversed with the UPC code.
And why was it important for you to get picture of the UPC code and the packaging of this glove?
There was a receipt located during a search warrant previously with the items on this receipt.
And in 9G, what are we seeing here?
This would be the reverse of the machete as it's hanging.
And on the reverse side of the machete, did you also get a UPC code?
Yes.
And did the UPC code from the packaging on the back of the machete match up to what was shown or depicted in the receipt?
Yes, they were the same items.
And in 9H, are we just zoomed in on that UPC from the machete?
Yes.
As part of your role in this investigation, did you also assist with the execution of the search warrant at 270 15th Street Northwest?
Yes.
Do you recall whose property or who lived there?
I know Mr. Van Patten was residing there with his brother and brother's girlfriend.
But that was the address associated with Dakota Van Patten?
Yes.
You weren't the lead detective or the lead investigator during the execution of that search warrant,
No.
right? Okay. Detective, I just want to back up briefly. I know that I asked you a couple of questions related to Trevor's work schedule Saturday night and you being able to confirm the hours that he worked. Do you recall that line of questioning?
Yes.
And when you confirmed the hours that Trevor worked at Lebowski's on that Saturday, did you see a printout that showed the hours that he logged in and logged out?
Yes.
And I want to bring you, I think originally when I asked you this question, you recalled that Trevor worked 8 to 5 that day. If you had an opportunity to see your report, would it help you clarify what the hours were that you verified Trevor worked that day?
Yes, it would.
Give me 1 second here. Your Honor, may I have your permission to approach the witness?
You may.
If you just take a second to review this portion of your report, let me know once you've had a chance to do that. You've had a chance to look at that?
Yes.
And after having reviewed your report, does that change your answer related to what Trevor's hours were worked on that Saturday?
Yes.
And what were the hours that Trevor worked that Saturday?
It worked 5 to 11 p.m.
PM?
p.m.
Thank you. I don't have any additional questions, Your Honor.
Cross? Thank you. Thank you, sir. We're going to go ahead and take an afternoon recess, 20 minutes. Jurors, please remember the admonition I've given you throughout the case. Have a good break, and we'll see you back in about 20 minutes. You can all be seated. Any record at this time needed from the state? No, Your Honor. From the defense? Yes, Your Honor. Can you turn your mic on?
Thank you. I'd like to make a couple records at this point. First of all, with respect to exhibits 7A through 7P, which were offered and admitted, I would just note that the state had properly listed foundation witness or witnesses for that previously. We had discussed that, and I had indicated that we would stipulate to foundation and the state could bring those in through whomever they wanted. So I just wanted to note that with respect to those exhibits. Second, I'd like to note for the record, a sidebar. I asked to approach. It was after there was evidence that there had been a sack of water and some cookies left during the Walmart checkout. Testimony was elicited that those were items that had been left by somebody else, and the witness specifically testified that my client took those items and left the store with him, which would be evidence of theft. We had filed a motion in limine prohibiting any other criminal or evidence of any other criminal activity. I believe that that evidence falls under that and should not have come in. I understand from our sidebar, and I'll defer to the state to make its record on that, that the state intended to offer that as evidence of something else other than bad character or other criminal acts. However, I would note that even if the court finds that to be true, it still has to do a balancing act of all relevant evidence to determine if its probative value is outweighed by its potential for prejudice. And in this case, it's our position that the evidence is more probative, or excuse me, more prejudicial than probative on that fact. Again, anticipating what the state will say, I would argue that it was cumulative. There was, and there will be, plenty of evidence as to the other items that were purchased there and those items having been found afterwards as well, which would go to identity. And so considering all of the other evidence that the state has and will offer to that point, it is unnecessary, and therefore it is more prejudicial than probative.
State like to be heard?
Yes, Judge. When conducting a 404B analysis, the question is whether or not the prior bad act is being offered to show that the defendant acted in conformity with, as propensity. If he committed one crime, he's more likely to commit another crime. The defendant is not charged in any way with a theft, and so I think that significantly reduces the propensity argument. Additionally, there are exceptions to prior bad acts evidence being offered and admitted. Those do include identity, amongst other things. One of the pieces of evidence found in the defendant's car during the execution of the search warrant were the bottles that were seen in that bag that were placed there by the employee that left the store in the defendant's possession. And so that it's extremely relevant. When it comes to cumulative evidence, it's not evidence piling on the same fact. Even if there were additional items found, which there were, during the execution of the search warrant in the defendant's vehicle, this is an additional piece of evidence that was also found. And so I do think that this is not cumulative, and I do think that it overcomes the 404B analysis, and that this is not being offered to show that the defendant acted in conformity with or to prove propensity for the character trait of being a thief, but for proof of the defendant's identity to associate him with the items in that bag later being found in his vehicle.
Any response?
No, thank you.
All right. First of all, I would state that defense counsel properly recited the sidebar as well as the agreement of counsel that the objection could be reserved until the next break. Certainly evidence of crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformance with that character. In this instance, the evidence is being offered for another purpose and not for propensity, namely being offered to prove identity, in that the item was found later in defendant's possession, and so it's being offered for a proper purpose and not for propensity. In terms of the balancing, court finds that the probative value is not substantially outweighed by the danger of unfair prejudice. Certainly, there's a significant probative value in terms of identity, that the very item that was found in defendant's possession was also an item that was identified as in the Walmart and taken. And in terms of the unfair prejudice, while theft is certainly a crime in the large scope of things, I don't believe that it's unfairly prejudicial when balanced against its probative value. Certainly not unfairly so, such that the danger would be, the probative value would be substantially outweighed by the danger of unfair prejudice. So the record's been made, the court's ruled on the same. Any further record on that issue?
I would just like to add for the record that the court is correct. The state would agree that the recitation given by Ms. Eimerman of our sidebar was correct and did reflect that conversation. And the state did agree to the timing of the motion being made. So I just want to put the state's voice on that as well.
The only other thing I would say, though, is that if requested, I think the defense would be entitled to limiting instruction as to its proper use. I wouldn't give that unless the defense requested it. That, of course, would bring greater attention to the fact. And so that's not something I would do unless the defense requested it. But if the defense did request that instruction, I would give that. Is that something that the defense is going to want? And if so, I would want to do that at the next available opportunity. But again, that's something I would only do if the defense would want me to do that, understanding that it would bring attention to the issue that's now been passed by.
Judge, my inclination is to agree with the court at this point that it would draw more attention needlessly to that. However, if the court will allow me to discuss with counsel and my client, and if we do, we'll bring that to the court's attention so it can be addressed soon.
Right. And if you would let me know before we get back together, in the event that such an instruction were given, I think it would probably be given in the context of, not to consider this as propensity, not to be considered on the, that, defendant is, they could only be considered on its proper value on identity, and brings attention to that issue. And so I can certainly give that instruction if it's desired, but obviously would only do that if you want me to. And if you do want me to, then I would like to talk with counsel specifically about the instruction to be given.
May I have just a moment?
Sure.
Judge, at this time, we're going to decline the court's offer to admonish the jury of that. My hope is, I understand, I appreciate the state's stated record with respect to that, and I trust that the state won't misuse that in closing or anything like that. And so at this point, I think with the state of the record where it is now, we'll decline to address it further with the jury.
And certainly if it were to be used in closing arguments, its proper purpose is limited narrowly to that limited purpose of identity, and certainly wouldn't be used for any other purpose.
Agreed. Thank you.
All right, thank you. So let's, I'll still give you your 20-minute break, and then we'll start promptly at 10 till. In terms of timing, am I correct that we've got one witness left?
Your Honor, so we have two witnesses scheduled because I'll fall short of this schedule. We're not supposed to be.
Do you want to turn on your microphone?
That's right, I'm just talking about it. They're not scheduled to be here till 3 because of my poor scheduling, which I'll try to do better at.
Okay.
Here. So we'll advise the court when they arrive. But we do have 2 more, and that's it for the day.
All right, and so if they happenly were to arrive earlier, then we'll start earlier. And I'll let the jury attendant know to let the jury know that the break may be a little bit longer.
Okay.
But as soon as you get your first witness here, we'll start.
Sounds good.
Great.
Off the record, but you're still going to give us 20 minutes.
We'll give you 20 minutes regardless. And if your witness is here by that time, we'll start then. Have a good break. So we're back on the record in FECR 153477. We're outside of the presence of the jury. I understand that there is an issue that council would like to take up outside of the presence of the jury in regard to a witness that's going to be proposed by the state. Who is that witness?
Brandon Monson, Judge.
Monson?
Yes.
And what is the nature of the issue?
Your Honor, the witness, Brandon Monson, would testify that he was in a vehicle on or about the night that Melody Hoffmanin was kidnapped and killed with other individuals, including Logan Kimpton, who's charged as a co-conspirator in this case, Taya Meyer, and then a person by the name of Dakota Cruz. And that during that car ride in the vehicle, Mr. Kimpton was talking openly about some plans that he had made with the defendant and Dakota Van Patten. And then I would anticipate that when we ask him, what did Logan Kimpton say, that Brandon Monson would say that defendant Kimpton said that he had plans with the defendant and Dakota Van Patten to go kill someone, but that he backed out at the last minute.
And what is the nature of the objection?
Your Honor, the objection is that while this might fit the first part of the statement against interest rule, that the second part that requires...
Can you cite a rule, please?
Yes. Hearsay exception, and the rule is 804B3, statement against interest as an exception to hearsay. And that I don't think we dispute that that would have a great tendency to be contrary to Mr. Kimpton's interests. However, that the second element of the analysis that would have to be supported by corroborating circumstances that clearly indicate its trustworthiness. And I understand that to bring this up now involves bringing in a statement from a deposition, whereas this is the trial. There's no doubt that Mr. Monson, who would be the witness today, made these statements in his deposition, but he also went on to say, I wasn't even sure if he was serious or not when he said this. And so we would contest that whether there is corroborating circumstances to indicate the trustworthiness of this statement, to make it a hearsay exception, to make it admissible. And so what we want to avoid today is a situation where the cat comes out of the bag and then Mr. Monson goes on to say, I wasn't even sure if he was serious about it or not, because he would then immediately be, and we would certainly have to elicit that testimony from him, he would then be questioning the trustworthiness of the hearsay statement that he was bringing into court today.
And so Mr. Monson's here is the plan to make an offer of proof so the court can make that finding.
Yes, we can do that, Judge.
All right, and does that work for the defense?
That works for us. Thank you, Your Honor.
All right, let's go ahead and do that.
I just need a moment to tell him what's going to happen.
All right, sounds good. All right, thank you.
Yes, sir.
Thank you, Your Honor. Could you state your name and spell for the record?
My name is Brandon Munson, BRANDONMONSON.
And have you been subpoenaed to testify in this trial?
Yes, sir, I have.
And previous to today, have you come here to the courthouse and provided a sworn statement and a deposition?
Previous to today, yes, I have.
During that deposition, were you asked questions about certain things you might know about this case?
Yes, sir, I was.
Do you recall being asked specifically about a car ride?
Yes, sir, I have. I do.
And do you recall that the car ride you were asked about would have happened on or about the night that Melody Hoffman was killed?
It was the night of.
And during that car ride on the night that Melody Hoffman was killed, who were you with?
I was with Logan Kempton, I was with Taya Meyer, and I was with another guy named Dakota Cruz.
And do you remember where you were seated in the vehicle?
I think I was in the rear passenger seat.
What kind of vehicle was it?
I don't know the exact year, but it was a mid-early 2000s F-150, Ford F-150.
Who was driving?
Dakota Cruz.
And do you remember where the other two were sitting?
Logan was in the front seat, front passenger seat, and Taya was in the back seat next to me.
Do you recall Logan Kempton talking openly about some plans that he had made with McKinley Louisma and Dakota Van Patten?
Yes, I do.
What do you recall Logan Kempton saying about the plans that he had made with the defendant, Mr. Louisma, and Dakota Van Patten?
I was told, the whole vehicle was told, that he had a plan to go murder someone. And he said that it was going to be that night, the night of the murder. And I lost my train of thought.
I'll ask another question.
Yes, sir.
Did he say who he had those plans with?
He didn't really say, he just said two other people.
Okay. So he didn't mention Mr. Louisma?
Not from what I can remember, no.
And what about Mr. Van Patten?
Not from what I can remember.
Do you remember, well, I already asked you this, but did you give your deposition in this case back on July 25th?
I did, sir. Yes, I did.
Did you review a copy of that?
I have it with me right here.
Okay. And have you reviewed that prior to today?
I have.
Do you remember being asked about this statement that Logan Kempton made in that deposition?
I do remember that, yes.
Okay. Do you remember what you said when you were asked if Logan Kempton gave any specifics about?
I don't remember that part, no.
If you had an opportunity to review that deposition, would that help?
If I did have an opportunity now, it would help, yes.
Go ahead. Can I approach witness, Your Honor?
You may.
I wish my memory was better.
Okay, I'm on page 11, line 14 in the deposition here. If
you would just, can you read that to yourself, page line 14, the question, and then your answer?
Okay.
Yeah, just to yourself first.
Oh, okay. Line 14, right?
Correct, yeah.
Okay.
Did that help refresh your recollection?
A little bit, yeah.
Okay. What did he say specifically about these plans?
He said that Dakota, had plans with Dakota and Ken over there to go murder someone.
At the time that he said this, do you remember thinking to yourself whether what he was saying was serious or not?
When he said it, I didn't know if it was serious or not.
Why?
Logan has been known in the past, back in like 2019 when I was friends with him, to joke around about that stuff.
Did you ask him any follow-up questions about that?
I did not.
That's all I have, Judge.
Questions?
Yes, thank you, Your Honor. Mr. Monson, good afternoon.
Good afternoon.
First, generally, do you have problems with memory?
I do.
And is there a reason for that?
I was abused in foster care and I got hit in the head a lot. I haven't been able to get a brain scan, but I believe it is from that.
Okay, thank you for sharing that. We have no further questions now, Your Honor.
Any redirect? All right, thank you, sir. You can step down.
Am I able to go out there then?
So you go ahead and step out to the lobby with the witness coordinator, and then you'll just wait with her for right now, okay?
Yes, sir.
Defense like to make any record?
Yes, Your Honor, briefly.
And I guess I should, before I let you do that, did that complete the offer of proof? Go ahead.
Thank you, Your Honor. So in addition to what raised the defense's concerns prior to the offer of proof, today, Mr. Monson needed a memory refresher with his deposition transcript just to be able to identify the fact that Mr. Kimpton had identified two other individuals who he supposedly was working some kind of conspiracy with. Mr. Monson fully admits that he has memory issues in general. And he again admitted today that he did not know if the statement was serious or not. And he gave further information, which is, to our understanding, new, I believe not offered in his deposition, that Mr. Kimpton had a tendency in the past to talk about these kinds of things. And that's what raised his suspicion about whether the statement itself was reliable. He thought at the time the statement may have been unreliable. He thinks today the statement may have been unreliable. And to that end, Your Honor, we think it should be excluded from testimony.
Mr. Maybanks?
Your Honor, we believe that we've established this is a statement against interest made at the time by Mr. Kimpton, and that a reasonable person in his position would not have made the statement. And it would only be made if the person believed it was true, because it was contrary to his pecuniary and/or propriety interests at this time, and does tend to also subject him to criminal liability. As far as the corroborating circumstances, here, the defendant was in a position, or the declarant, Mr. Kipton, was in a position of being in a vehicle with friends of his. It would seem that he would trust these friends in order to say something that would be so incriminating in their presence. We also would contend that the circumstances are also corroborated not only by the statement itself, but by what had happened up to that point in time. As the court has received and the jury has heard as evidence in this trial, that prior to this, Mr. Kipton had been with these two individuals and purchased with them 2 machetes and gloves, only to not be with them then shortly after that, and then talk openly about this conspiracy, this plan. So we believe that the circumstances altogether in this case does tend to indicate that the statement was trustworthy when it was made for those reasons. We believe also an argument could be made that this is a statement by a co-conspirator as well.
And as to that second argument, is that something that the state's offering, and do you wish to develop that as an alternative?
Your Honor, given the same arguments as far as the nature of the statement and when it was made, the circumstances surrounding the statement, we do believe that we have shown that this is more than just an individual who was bragging openly about being involved in a conspiracy, that he had actually taken steps at that point in time in furtherance of the conspiracy, and that the conspiracy was actually ongoing at the time that he made the statement. Clearly, he had not done anything to stop the conspiracy, to report the activity or otherwise. So we think the evidence can show that there was a conspiracy that existed between the defendant here in this declarant, that it's being offered against one of the members of the conspiracy, that it was made during the course of the conspiracy, and in furtherance of the conspiracy.
And you want to set a rule?
That is Iowa Rule of Evidence 5.801D2E.
Mr. Moore, do you want to respond to state's alternative argument?
May I respond, Your Honor?
You may.
Your Honor, these statements are not statements of a co-conspirator. These statements are simply idle chatter. State v. Countryman, 572 Northwest 2nd, 553. In fact, Mr. Monson was asked in his deposition if he believed that Mr. Kipton was trying to solicit his help in any way in this, and he responded, no. I'm sorry, I can't find that exact spot in the deposition. There is no indication that he was making those statements in any attempt to further a conspiracy, if in fact the court believes that a conspiracy existed at that point. Again, I believe that the Countryman case would support that this was merely idle chatter.
Thank you. With regard to the corroborating circumstances, would the defense care to respond to the state's argument that the other facts of this case was established in the evidence thus far, including the purchase of the machetes, evidence that the three individuals were photographed together, etc., itself provide the corroborating circumstances necessary to meet the prong at 3B.
Yes, Your Honor. The corroborating circumstances required by the rule are circumstances that indicate the trustworthiness of the statement. The facts regarding purchases at Walmart may corroborate the truth of the statement, but not necessarily its trustworthiness, whereas Mr. Monson himself questions the trustworthiness of the statement that Mr. Kimpton had made such statements in the past before, but that were not trustworthy. And to that end, we just say there's nothing to indicate that what Mr. Kimpton would have said that day could be taken by Mr. Monson as trustworthy.
All right. First of all, I do agree with the defense. These do not appear to be statements of co-conspirators. Do not qualify as such. However, I'm going to overrule the defense objection as to these not qualifying as statements against interest. Based on the offer of proof made. Statements were contrary to declarant's interest. As being so great as to expose the declarant to criminal liability. It's pretty obvious. And I do think the corroborating circumstances are strong enough to indicate their trustworthiness. So that objection is going to be overruled. The court's going to find that these do qualify as statements against interest, and so the testimony will be permitted. And defense counsel will be able to challenge the quality of the statements through cross-examination. Any further record that's needed?
No, Your Honor.
All right. So at this point, can we get our jury back in, and which witness are we going to hear from next? All right.
To report the activity or otherwise. So we think the evidence can show that there was a conspiracy that existed between the defendant here and this declarant, that it's
it's being offered against one of the members of the conspiracy, that it was made during the course of the conspiracy and in furtherance of the conspiracy.
And you want to cite a rule?
That is Iowa Rule of Evidence 5.801D 2E.
Mr. Moore, do you want to respond to state's alternative argument?
May I respond, Your Honor?
You may.
Your Honor, these statements are not statements of a co-conspirator. These statements are simply idle chatter. State v. Countryman, 572 Northwest 2nd, 553. In fact, Mr. Monson was asked in his deposition if he believed that Mr. Kimpton was trying to solicit his help in any way in this, and he responded, no. I'm sorry, I can't find that exact spot in the deposition. There is no indication that he was making those statements in any attempt to further a conspiracy, if in fact the court believes that a conspiracy existed at that point. Again, I believe that the Countryman case would support that this was merely idle chatter.
Thank you. With regard to the corroborating circumstances, would the defense care to respond to the state's argument that the other facts of this case was established in the evidence thus far, including the purchase of the machetes, evidence that the three individuals were photographed together, etc., itself provide the corroborating circumstances necessary to meet the prong at 3B?
Yes, Your Honor. The corroborating circumstances required by the rule are circumstances that indicate the trustworthiness of the statement. The facts regarding purchases at Walmart may corroborate the truth of the statement, but not necessarily its trustworthiness, whereas Mr. Monson himself questions the trustworthiness of the statement that Mr. Kimpton had made such statements in the past before, but that were not trustworthy. And to that end, we just say there's nothing to indicate that what Mr. Kimpton would have said that day could be taken by Mr. Monson as trustworthy.
All right. First of all, I do agree with the defense. These do not appear to be statements of co-conspirators. Do not qualify as such. However, I'm going to overrule the defense objection as to these not qualifying as statements against interest. Based on the offer of proof made. Statements were contrary to declarant's interest. As being so great as to expose the declarant to criminal liability. It's pretty obvious. And I do think the corroborating circumstances are strong enough to indicate their trustworthiness. So that objection is going to be overruled. The court's going to find that these do qualify as statements against interest, and so the testimony will be permitted, and defense counsel will be able to challenge the quality of the statements through cross-examination. Any further record that's needed?
No, Your Honor.
All right. So at this point, can we get our jury back in, and which witness are we going to hear from next? All right. You can all be seated. Is the state prepared to call its next witness?
Yes, Your Honor. The state calls Brandon Monson.
Sir, if you'd please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I swear.
Sir, if you'd please start off by stating and spelling your full name for the record.
My name is Brandon Munson, BRANDONMONSON.
Thank you, sir. Go ahead, counsel.
Thank you, Your Honor. Good afternoon, Brandon.
Good afternoon.
May I ask you a few questions about yourself first?
Yes, sir.
Know who you are. How old are you?
I am 20 years old,
And where do you currently live?
here in Cedar Rapids.
Do you have your own residence?
No, it's a host home. I don't know if you've ever heard of a HAB home, but it's kind of like that, but the staff actually live with you.
Okay.
And it's the staff member's house, basically.
How did you get lined up with that?
Through Four Oaks.
Is this some kind of housing then where you have staff there to help you with things?
Yes, I'm currently working on money management and cleanliness, like cleaning up my room and stuff.
And do you work for a living?
No, I do not.
How are you able to afford to live in this house?
I get it paid for through Medicaid.
How long have you been there?
Since the beginning of September. I want to say the 3rd.
Where were you living before that?
I was living with my grandpa down in Iowa City.
And then going back a little bit further than that, where were you living back in February of this year?
Half of the month of February, the first half I was homeless, but on February 14th, I moved in with Taya Meyer in her apartment in Marion.
Do you remember the address of that apartment or what apartments they were?
I know the address.
Go ahead.
1790, or wait, no, 690 Bentley Drive in Marion, Iowa. Sorry about that.
That's okay. So you said you were living there with Taya Meyer?
Yes, I was.
And who's she?
She is a friend of a friend.
Besides Taya Meyer, were you living with anybody else at that address back in February?
Yes, but I couldn't really name those people off the top of my head.
How'd you meet Taya Meyer?
I met her through Logan Kimpton back in December of last year.
And so you're saying you know Logan Kimpton?
I do know Logan Kimpton, yes.
How do you know Logan Kimpton?
I met him through school back in 2016, towards the end of the year that year. And I didn't have very many friends, so I just made friends with whoever I could.
What school is that?
Polk Alternative.
Is that a high school then?
They have beginning of middle school through high school.
So while you attended Polk Alternative, that's where you met Logan Kimpton?
Yes, sir.
And as of February of 2024, was Logan Kimpton your friend?
At that point, he was, yes.
I'm going to ask you about a couple more people. Do you know somebody by the name of Dakota Van Patten?
I do.
How do you know him?
I know him through Logan. I didn't really consider him a friend, but I just knew of him, and I hung out with him a few times, but I wouldn't really consider him a friend.
So you hung out with him a few times. Does that mean that you would be able to, recognize him in person?
I would, yes.
And do you know the defendant in this case, McKinley Louisma?
Yes.
How do you know him?
I know him through Logan Kimpton.
What kind of prior interaction did you have with him?
He only gave me a ride from St. Luke's Hospital to Taya Meyer's apartment in February, and that is all I remember about him. I didn't talk with him much during that car ride. He just gave me a ride over there.
And do you see him in the courtroom today?
Yes, he is sitting right over there.
He's got the blue shirt on by his lawyers?
Yes, sir.
Okay. May the record reflect the witness identified the defendant, Your Honor?
It will.
What did you know the defendant as?
Just one of Logan's friends. I knew him. People call him Ken.
Now, this is a case involving the homicide and kidnapping allegations involving Melody Hoffmanin. You understand that?
Yes, sir.
Do you recall being in a vehicle with Logan Kimpton, Taya Meyer, and another person on or about the night that Melody was kidnapped and killed?
I do recall, yes, sir.
And who was the other person, if you remember?
Dakota Cruz.
Do you remember what you guys were doing that night in the vehicle?
We were mudding out in Solon.
What's muddy?
Mudding is where you go off-road a whole bunch of mud and you try to kick it up with your truck.
Okay. Who was driving?
Dakota Cruz.
Was it his truck?
It was his truck.
Okay. And can you tell us, if you recall, where people were sitting in that car ride?
I was sitting in the rear passenger seat. Taya Meyer was sitting in the rear driver's side seat. Logan Kimpton was in the front passenger seat.
During that car ride, was Logan Kimpton talking openly about some plans that he had made with the defendant, Mr. Louisma and Mr. Van Patten?
Yes, sir, he was.
What did he say about the plans he had with those two?
He said that he had a plan to go murder someone and that it was going to be with the defendant, Ken, and Dakota Van Patten.
When he said that he had a plan to go murder someone with the defendant and Mr. Van Patten, did he tell you when that was supposed to happen?
He said it was supposed to happen that night.
Do you recall what, if anything, Mr. Kimpton said about how they were going to do this?
I do not recall.
When Mr. Kimpton said this, what was your thought?
I didn't know if he was joking or not because he has been known to joke around about killing people in the past.
After that car ride, where did you go?
We went back to Taya's apartment.
And when you went back to Taya's apartment, where you were staying at the time, what did you do?
I went to sleep.
Do you recall, as you sit here, approximately what time that would have been?
Between 3 and 5 a.m.
So you think you went to sleep when you got home around maybe 3 a.m. or so?
Yes.
Do you recall, while you were in the apartment that night and you got home and sleeping, do you recall Mr. Van Patten coming to the apartment?
I do not recall from my own memory of seeing him, but I remember Taya told me he was
okay.
there. Sorry.
Thanks, Mr. Monson. We just want you to talk about what you remember.
Sorry about that.
No, you're just answering the question. That's fine. So you don't recall seeing Mr. Van Patten?
No, but I do know he was there.
That's all I have, Judge.
Cross.
Thank you, Your Honor. Good afternoon, Mr. Monson.
Good afternoon.
Generally speaking, do you have problems with memory?
I do.
And we have talked to you about your memory of this truck ride with Logan Kimpton and some others. Do you recall giving a deposition in the summer?
I do recall that.
And we've talked to you about that car ride again here today, correct?
Yes, sir.
And as you walked into this courtroom, this courthouse today, did you even recall the specific detail that Logan had implicated McKinley Louisma and Dakota Van Patten with his statements?
I don't remember exactly what I said, but I remember roughly about what I said.
And did someone have to refresh your memory of that particular detail today?
Someone did have to refresh my memory on that detail, yes.
No further questions, Your Honor.
Redirect.
Thank you, Your Honor. You were asked about whether you had memory problems, Mr. Monson?
Yes, sir, I did. I was.
And what, to your knowledge, what's the cause of those potential problems?
It was, to my knowledge, abuse I sustained in foster care. I got hit in the head a lot.
When you were initially contacted in this case, did you talk to
some Marion police investigators?
Yes, I did.
And did you tell the Marion police investigators when they talked to you what Logan Kimpton said in that car?
Yes.
And when you did a deposition this summer in July, did you take an oath to tell the truth?
Yes, sir, I did.
And during that deposition, did you tell these lawyers and did you tell them what Logan Kimpton said in that car?
I did say yes.
And that's what you reviewed before today, right? Before testifying today, right?
Yes.
And did you tell the truth to the police?
Yes.
Did you tell the truth in your deposition?
Yes.
Are you telling the truth today?
Yes, sir, I am.
Nothing further.
Recross?
No, Your Honor, thank you.
Thank you, sir. State can call its next witness.
State calls Taya Meyer.
I'm going to have you raise your right hand.
This one?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
And if you would please state and spell your full name for the record.
Taya Joe Meyer.
All right, and I'm going to have you speak right into the microphone in front of you. You could turn it, pull it down a little bit so you're closer. It bends. Right.
Taya Joe Meyer.
And how do you spell that, ma'am?
Taya Jomeyer.
Thank you. Go ahead, counsel.
Thank you, Your Honor. Taya, how are you today?
Decent.
Okay. You look like you're having some trouble in here. Are you feeling all right?
Yeah, just not feeling good. I'm a little dizzy and just been sick.
Are you able to answer some questions for us today?
Yes.
And answering those questions, you're going to tell us the truth?
Yes.
Need a break or anything, let us know, okay?
Okay.
Let's start with some easy ones here. How old are you?
What?
How old are you?
20.
And where do you currently live? In what town?
Marion.
How long have you lived in Marion?
I'd say almost a year.
Who do you live with?
My boyfriend.
What's your boyfriend's name?
Landon.
Are you working right now?
No.
Is Landon working?
Yes.
You guys renting somewhere?
Yes.
Do you help Landon out with his work?
Yes.
What's he do?
DoorDash.
I'm going to ask you if you know a few people, okay?
Okay.
First of all, do you know the defendant in this case, Mr. McKinley Louisma?
Yes.
And who do you know him as? What did you call him?
Just Ken.
Ken?
hmm
How do you know Mr. Louisma or Ken?
I know him through Logan Kimpton.
How do you know Logan Kimpton?
I've known him since I was little. I know his whole family, and
Okay. How long has that been?
since I don't know, probably like 5, 6, maybe 7 years.
Is Logan related to your boyfriend?
Yes.
How?
He's his cousin.
Do you know Dakota Van Patten?
Do I or did I?
Did you?
Yes.
And how'd you know Dakota Van Patten?
Also through Logan.
When do you think you met Dakota Van Patten?
I'd say December of last year.
By last year, do you mean December of 2023?
Yes.
How would you describe your relationship with him back in February of this year with Dakota Van Patten?
We were cool. We hung out sometimes. I mean, we were friends, but not friends.
So you're cool, you'd hang out sometimes, and friends, but not friends? What's that mean?
Like, we really wouldn't, like, I don't know, it's just, we hung out and we wouldn't really call each other friends. Like, we just knew people that knew people.
Did you know common people?
Huh?
Like, did you guys know common people?
Yes.
Okay. Did Mr. Van Patten ever come and hang out at your house back then?
Yes.
Did you ever let him stay at your house?
Yes.
Going to the night of February 17th into 18th. So I want to ask you, before that, had Mr. Van Patten stayed at your house like the night before that?
Yes.
We'll get back to him in a minute, but I want to ask you if you know somebody by the name of Melody Hoffman, or did you?
Yes.
How did you know Melody Hoffman?
Like Snapchat, she added me off of mutual friends or a quick ad, and that's just how I knew her. We really didn't talk. She was just on my Snapchat.
Did you ever hang out with her in person?
No.
Did you know whether she was friends with some of your common friends?
No.
Where were you living back on February 18th of 2024?
In my apartment in Marion.
Remember the address of that apartment?
690 Bentley Drive, Marion, Iowa.
Who were you living with then?
Brandon.
Anybody else?
No.
Would some other people stay there once in a while?
Yes.
Your friends and stuff?
Yes.
So you know that you're subpoenaed to testify in this case, and it's the case involves the homicide of Melody Hoffman, right?
Yes.
Do you remember the time when Melody Hoffman was killed?
Not the time, but I know it was like in February.
Did you have contact with Dakota Van Patten on or about the night that Melody Hoffman was killed?
Yes.
Could you tell us first, how did you end up having contact with Dakota Van Patten the night that Melody Hoffman was killed?
He called me and asked me if he could come over and he needed to talk to me.
When he called you, what were you doing?
I was just laying in my room, just laying down, hanging out with my dog.
When he called you to ask if he could talk to you, what did you tell him?
I said, sure, I guess. I mean, I was gonna go to sleep, but I guess.
Did he tell you where he was when he called you?
No.
Did you end up then having contact with him in person?
Yes.
How'd that happen?
He told me to come downstairs and he asked if we can go upstairs. He tried to give me a hug. I said, no, get away from me. What is this about? Just get to the point. And then we headed upstairs.
So he was downstairs. Was he outside of the residence first?
Yes.
And then he asked to come upstairs, meaning into your apartment?
Yes.
And did you let him into your apartment?
Yes.
And when you got into the apartment, where did the two of you talk?
In my room.
In your bedroom?
Yes.
When he came into your bedroom to talk, did you ask him what's up?
Yes.
Okay. Can you describe, before I ask you what he told you, can you describe what his demeanor and appearance was, like how he's acting?
He was just chill, really didn't talk. Like, he was just not acting like himself, but like, I don't know. He was just chill and he just had a weird type of aura or vibe to him. So.
What did he tell you that he wanted to talk to you?
Yes.
Did he tell you how he got to your apartment?
He told me that he got here by a car. He didn't tell me who. It was just like, I didn't like see because it was dark. It looked like a black car, but I didn't know.
Did he tell you who he was with that night?
No. Yes, he told me he was with Ken.
So tell us about the conversation, starting with him wanting to tell you that he really wanted to tell you something. What did you say to him?
So I closed my door. I said, so what is this about? I want to go to bed. Like, what are you here for? And he was just like, why do you need to tell you something? I said, well, get off your chest. Tell me, like, what's going on. And he was like, I killed someone. I said, who, why, what the fuck, what for? And he was like, that Melody girl. And I was like, for what? She didn't do anything to you. Who, why would you do that? Who with? What was the reason? He was like, with Ken. And then I said, for what? Why are you at my house? I don't want any part of this. And then
Okay, I'm going to stop you for a second so we can break that down, okay? When you said, what is this about? And he said he wanted to tell you something, your testimony is that Mr. Van Patten said that he killed somebody.
Mm-hmm.
Is that yes? Okay. Is that a yes?
Yes.
Okay. And what did he say to you about who he was with when he killed her?
He just said he was with Ken, and he really didn't say anything more about it. I said, why? And I said, why did it happen? And he just said it had to be done. And he really didn't talk to me afterwards.
Did he tell you about whether Ken was involved in it or not?
Yes.
What did he say?
He just said, I said, was it with anybody why did you do this? And he said it with Ken. That's all he told me.
What, if anything, did he do when he told you this? Was he trying to gain sympathy from you, or?
I really don't know. He was trying to like lean more towards me, and I think he was trying to give me a hug again. He really just off after he told me, and I was just shaking and scared, and I just was trying to back up from him, stay away from him.
Did you let him hug you?
No.
What did you tell him after he told you that he was with Ken and he killed somebody?
I told him to get out. I said, you don't need to be here. You can go in the living room, wait for a ride, and you can do whatever you need to do. I don't want you around here. I'm a girl. Like, that could happen to me. That could happen to anybody. And the fact that you're going to tell me this is crazy, and I just don't want to be a part of it. That's, that's not something you just tell somebody.
Did his demeanor or his emotional, condition change at all then?
No, he was just chill. No tears, no source of sympathy, nothing.
Did you see any weapons on him?
No.
I'm sorry, what'd you say?
No.
Did you tell the police about seeing any weapons on him?
No, I don't think so. No.
What did you say? Could you repeat that?
I said no. What I can recall, no.
1 second, Taya.
Okay.
Taya, when Mr. Van Patten told you that he was with Ken and that he killed someone, did he tell you what he did, what Ken did,
No.
what they may have done together?
No.
Did he offer any more details about that?
No. He just said it had to be done.
He just said it had to be done?
Yes.
How did you feel when Mr. Van Patten told you all this?
I was scared. I wanted to cry. I wanted to, call the cops, but I didn't know if he was gonna hurt me. I was just terrified, trying to get him out of my house.
Did he end up leaving your house?
Yes.
So he didn't stay the night there?
No, he wanted to, but I told him he had to leave because I didn't want to get killed in the middle of the night or anything. I just wanted him out. I didn't want him around me. I just felt terrified. I called my grandma afterwards and was just scared.
Did you ask him any more details about what happened?
I tried. I said, why? What happened? What did you do? He's stayed with the store and said it had to be done.
I think that's all I have, Judge.
Cross?
Yes, Your Honor. Good afternoon, Ms. Meyer.
Morning.
Regarding these three young men, Mr. Louisma, Mr. Kimpton, and Mr. Van Patten, had you seen any of them with machetes prior to this date?
Before, you meaning?
Yes, before Ms. Hoffman's death.
I don't think so. No.
Ms. Meyer, I'll ask you, do you recall giving a deposition on July 25th of this year?
Yes.
And do you recall giving a statement to me and Ms. Eimerman and other attorneys that day?
Yes.
And do you recall taking an oath that you would tell the truth on that day?
Yes.
Do you recall if we had asked you on that day whether you had seen any of these young men with machetes before?
Yes.
Do you recall your answer that day on July 25th?
No.
You don't recall your answer?
No.
If I showed you the transcript of that deposition, would it refresh your memory?
Yes.
Your Honor, may I approach?
You may.
Counsel, I'm looking at page 17 of Ms. Meyer's deposition, lines 2 through 25. Okay. All right.
Yes.
Ms. Meyer, did that refresh your memory of the answers you gave on July 25th?
Yes.
And did you say you had seen those individuals with machetes before?
Yes, just a few days like prior to the day you were asking, like Tuesday, Wednesday.
Okay. And did you think anything of seeing those machetes?
No.
And were they within the context of kind of just lying around?
Yes.
Okay. And also, Ms. Meyer, today, you gave some testimony about some statements that Dakota Van Patten made to you when he came to your house late on February 18. Is that correct?
Yes.
And you said that he told you that he had killed someone,
Yes.
but today you also said that he told you he was with McKinley Louisma when he killed someone?
Yes, I didn't remember at first, and then when I've been trying to remember everything, I did remember my statement to police or whatever, and I was like, oh yeah, not I remembered him say that he was with Ken, but he didn't say anything other than it had to be done, and nothing about other than Ken was with him.
Okay. And again, I'll ask, do you recall your deposition from July 25th of this year?
Yes.
And do you recall detailing the statement in which Mr. Van Patten said that he had killed someone at that time?
Yes.
And do you recall what you said on that day about who he was with?
I think I said he was alone. I'm not for sure.
And so you think on July 25th you said he wasn't with anyone else?
Yes. Yes.
I don't have any further questions, Your Honor.
Redirect.
Taya, do you remember on the date of that deposition that I also asked you some questions?
Yes.
And you remember me asking you about whether you remember telling police officers when they interviewed you that Mr. Van Patten said he was with Ken? Do
Yes.
you remember what you said at that time?
No.
And would being able to reference the deposition be able to help you recall what you said when I asked you that?
Yes.
This is page 45, line 6. Page 45, line 3 is where the question is. Can you just read that answer to yourself first? What did you say then when I asked you that day?
I said I don't remember. I don't know. I said also maybe, but I just couldn't remember on the top of my head.
Prior to coming in to testify today, did you have a chance to watch an interview that you had with the police when they were asking about this?
Yes.
And then that interview, did you say to the police that Mr. Van Patten said when he was talking about killing Melody Hoffman that it was he and Ken that did it?
Yes.
Is that what you told the police?
Yes.
That's all I have, Your Honor.
Cross?
No, Your Honor.
Thank you, ma'am.
Thank you.
Does the state have any other witnesses today?
Your Honor, we don't have any other witnesses today scheduled.
All right, jurors, so we're out of witnesses today, so I guess it's going to be an early day. I'm going to release you until 9 o'clock tomorrow. I want you to remember the admonition I've given you throughout the case. One thing I wanted to mention as well, I meant to mention it yesterday, or I guess Friday or this morning, but there is a camera in the courtroom. I wanted the jury to be assured that you'll never be shown. So as jurors, that one of the rules of our court is that jurors will never be shown. So I just wanted you to be assured of that. So have a good evening, and we'll see you tomorrow morning at 9 o'clock.
You're listening. Oh, that's loud. You're listening to the Outcast podcast here on YouTube. Day one of the body dumped murder trial, Iowa versus McKinley. And we'll try to say that last name. The jury is going out for the day. It's 4:11 there. Well, a little after 4 o'clock there. Hopefully everything is going to go smoother tomorrow with them. Hard to say. But we shall see. And let's see what else is going to happen the rest of today.
You can be seated. Any record needed from the state? From the defense? All right, we'll be in recess until 9 a.m.
And they are going on recess until 9 a.m. tomorrow, which is 10 a.m. our time. And so we'll have to wait and see what happens there. All right, I need to see. But this is Outcast Podcast, folks. I'll be back with you tomorrow. Thank you so much for stopping in if you do, watching the replay. I'm going to leave you with a little bit of music and then I'm going to close it out. This is the Outcast Podcast.